Hi, everyone. We're going to go ahead and get started just so I don't, given the technical difficulties that we had, I don't eat into our first presenter's time too much. Thank you, everyone, for being here today. And thank you to our panelists for agreeing to present, and also to the Capital District Black and Hispanic Bar Association for agreeing to co-host this CLE with us. Just a few housekeeping matters before we get started. Everyone should have received their materials this morning at the email address that you registered at. If you registered after 9 a.m., please shoot me an email. I will get those materials to you ASAP. I will put my email into the chat once we get started. There will be 3 CLE certificate credit codes that pop up throughout the CLE. I will also announce them just in case anyone has their screen minimized temporarily, of course, during the CLE. I will also re-announce the codes at the end of the CLE, just in case anyone missed one. And then finally, we are hoping to have a Q&A session at the end of each presentation. In the event that a panelist goes up to their time, though, and we're unable to have a Q&A session, we will have a general Q&A at the end, so feel free to just post your questions in the chat, and I will be monitoring those and I will read them accordingly. And so with that, we'll go on and get started with our first presenter, who is a colleague of mine, Robert Romaker. Robert Romaker is a managing attorney at the Legal Aid Society of Northeastern New York in the Albany office. He graduated with a BA from The Ohio State University, majoring in political science and minoring in Spanish. He obtained his JD from the University of Toledo College of Law. He has been a legal aid attorney for his entire career and has done many presentations in and around the Capital District on evictions and other landlord-tenant issues. Mr. Romaker started his career as a staff attorney for Southeastern Ohio Legal Services and later became a managing attorney at Seals and continued in that position for 12 years when he moved to New York. He started with LASNNY as a staff attorney in the Amsterdam office. He later became a supervising attorney with LASNNY. Mr. Romaker then became a managing attorney in the Albany office, a position he has now held for almost 9 years. He supervises the majority of the housing attorneys in the Albany office. He lives in Albany with his wife, Jane Ann, his stepson, Matthew, and their dogs, Zeke and Sadie.
Thanks, Mallory. Hi, everyone. Thank you all for attending this CLE. Hopefully we'll make it as interesting as possible. And I am going to start out today with the introduction to summary eviction proceedings. Go ahead and click me through if you would. So this is just this slide here is just the overview of what we're going to be talking about. A few things I want to highlight on this slide is that I will just be glossing over the defenses that are in my part of the PowerPoint because Jasmine Greenfield, my colleague out in Amsterdam, is going to be doing the defenses. So I'll be glossing over that. The other thing is that when you see print in red on the slides as we go through them, that means that it's provision that is new and a part of the Housing Stability and Tenant Protection Act of 2019. 2.5 years ago, wouldn't be new in normal circumstances, but given COVID and the courts largely not being open, it feels like really new. I don't know that there's been a lot of decisions under the new law, but anyway, when you see anything in red, that means it's new-ish, I guess. So next slide, please. All right, the basics of landlord-tenant relationships in New York. Basically, landlord-tenant relationship involves a tenant who reaches an agreement and pays for an exclusive possessory right to a housing unit. The tenant has a leasehold interest, however, the landlord maintains an ownership interest, just divests the possessory rights to the tenant. The tenant has protections and rights and obligations as the person with the leasehold interest, as does the landlord. And obviously the tenant's protections are limited by the landlord's ownership rights. Next slide, please. Okay, to the definitions. Under New York law, a tenant is a person occupying or entitled to occupy a residential premises either because they're a party to a lease agreement or they're a statutory tenant under rent control law, which we don't have here, or the other law, which is also not applicable here. So basically in our upstate, the tenant is occupying under a residential rental agreement, either written or oral. The key piece on this slide is the 30 days. A tenant also includes an occupant of a rooming house or a hotel, not including a transient occupant, but if they've lived there for more than 30 days or 30 days or more, they're considered a tenant, and that means they're protected by the statute that says they can't be removed except in a special proceeding, and that's under RPAPL 711. The 30 days is important because a lot of times, if like the police get called to a hotel because the hotel is having an issue with one of the residents, it's always important for the 30-day question to be answered, because that's the mark. It seems like something almost that would be street law, but it really isn't. It actually is the law in this instance. So that's always important for people in short-term tenancies, especially, or in a hotel, to be able to prove that they've lived there for 30 days or more. How tenancies are formed is this slide. And obviously the execution of a written lease, which I would say we see in, I don't know, 30% of the time, maybe a little bit less. Mostly it's an oral month-to-month agreement is what we see, not written leases that much, or by implication. There's a, if you go and if you're a tenant and you're looking for a place and you pay money for a unit, it's likely that you become a tenant. And also some person who is being housed by DSS at a motel, which is sometimes where they put people for shelter, can qualify as a tenant again once they stay past that magical 30 days. Next slide. All right, so basically the different types of tenancies by term are either a term lease, which is usually 1 year, can be for 1 month or 6 months or 2 years, but usually it's one. And then again, there also are month-to-month leases can be written or they can be verbal. Most of the time they're verbal, but those are the kind of leases, those are the tenancies by term that are created in New York. Next slide, please. Now this slide is, gets into a little more detail. These are people who reside, but they are not tenants, but they still have rights that protect them under New York law. A licensee, this has the formal definition here. What I usually tell people that ask me what a licensee is a licensee is someone who was granted permission to be there, either by the landlord or by another tenant, and now that permission has been revoked. There's no tenancy created, but they still have the right to 10 days notice, and they of course have to be removed in a summary proceeding. Contrast that with a squatter, who is a person who enters into possession of the property without permission of anyone, who has no property rights, except they're also entitled to a 10-day notice and have to be removed by a summary proceeding. Licensees we see quite a bit, squatters pretty rarely, although seems more and more we see cases where the tenant is alleged to be a squatter when actually they're a tenant or they're a licensee. Not every day, not every week, but we have seen a few of those, I would say, in the last 6 months. And oftentimes they're not a squatter at all. It's just it's a label that is put on them, I guess, because the landlord or their attorney perceives that as a status that makes it easier for them to be removed than if they're a tenant or a licensee. There's also an employee. Sometimes, like if you have a property manager, they take the rent, take calls, arrange maintenance, but they also rent an apartment in the building. So if that's the case and their employment contract involves staying in a resident, if they lose their job as a property manager, either they quit or they get fired or their job's just terminated, then their right to housing has also ended, and there's no notice required for them, which is curious. It's that a squatter would be entitled to more notice than an employee, but that's in fact what the law is. An occupant or roommate, I mean, this involves the roommate law, where a person, the tenant and the tenant's immediate family and one other person, I believe, and their children can occupy the premises with the consent of the tenant. And I don't think that the landlord has the right to restrict that in contravention of the statute. A very interesting and curious provision in New York law. I think the time that I encounter that most is at these presentations, because there's a lot of interest in it. I don't really see it that much in practical application, except as that interfaces with federally subsidized housing and the requirement that you can't have unauthorized residents, largely because it's income based. And so the intersection between the New York roommate law and the federal regulations that allow housing authorities and other subsidized landlords to evict tenants for having an unauthorized resident, that we've seen that some. But other than that, it's at least in our practice, it's more of a kind of a practical theoretical interest, and it's something that we see litigated or come up in cases very often. Family members, there's a body of law in New York that's really kind of all over the map about whether, you know, we've had cases before where a couple lives together, they're not married. One member of the couple owns the house, the other one does not, and then they break up. And so then the owner of the house wants the person who is not the owner of the house to leave, and so they file an eviction. And then there's a question, especially if they have children in common, whether, you know, it should be in another court or whether that should be in housing court. I know there was the well-known case where the parents were trying to evict their son from their house. And I don't even remember exactly how that came out. I just know that if you are looking to find cases about family members to protect the person who's being evicted, I think you can find those. And I also think if you're representing the person who is seeking to evict, the boyfriend, girlfriend, spouse, nephew, son, whatever, you can find those cases too. I think they're kind of all over the map, frankly. Next slide, please. Okay, so to moving into what a summary proceeding is, when a landlord files a petition and a notice of petition in court seeking to evict a tenant, that's called a summary proceeding. It's governed by Article 7 of the RPAPL, which is the Real Property and Proceedings Law, and also Article 7 of the Real Property Law, which is the RPL. RPAPL, I just say it that way. Some say RP Apple. I don't know. It's one of those acronyms that doesn't really lend itself to saying anything easy. So anyway, it's an expedited version of a civil lawsuit. It's kind of, if you've not been involved in these proceedings before, it's kind of similar to if somebody's filing for a temporary restraining order and a preliminary and permanent injunction. It is an accelerated, expedited version of a lawsuit that happens much more quickly than, you know, other civil lawsuits. The notice of petition basically serves as a summons. It puts the date on of the first appearance as well as the location, and it usually includes language about what the landlord is seeking and what the tenant needs to do to protect their rights and things like that. If there are triable issues of fact, the parties are entitled to a trial. They're entitled to a jury trial if they elect that, as long as they ask for it in either the petition or the answer. That is exceedingly rare. I don't know that I've seen a jury trial in a summary proceeding such as this. I don't know that we've asked for jury trials very often. It's something that's there that people don't generally use, in my experience. So summary proceedings are solely for the recovery of possession of property. If a dispute arises regarding a landlord-tenant issue that doesn't involve possession, then a civil plenary action, including a small claim action, is the proper action to commence. These summary eviction proceedings can be brought in Supreme Court or local city court or local town and justice or village court. Local court is much more common. I don't think that evictions are filed in Supreme Courts hardly ever. The types of summary proceedings. We have a case actually recently where somebody is trying to make a third type of proceeding in New York, but I think the law only provides for these two. One is the non-payment proceeding under RPAPL 711-2 can only be brought when the tenant has defaulted on the payment of rent. And now under the newish law, the 2019 law, rent is clearly defined as the monthly or weekly amount charged in consideration for the use and occupation of a dwelling pursuant to a rental agreement. No other fees or charges or penalties, late fees, filing fees, service fees. It used to be under the old law that if you called them these things added rent in the lease, then they became rent and they could be subject to eviction. The 2019 law got rid of that. So now it's just rent only. A holdover proceeding is the other type of proceeding under RPAPL 711-1. Can only be brought when a tenant holds over past the expiration of their tenancy. There are different kinds of holdovers. I usually break it down into a for-cause holdover when there's an allegation that the tenant has breached the lease, and that's the basis for an eviction. And then there are no-cause holdovers, which are simply holdover proceedings that are brought because the rental agreement has expired or been terminated, and the landlord doesn't want to, or the tenant doesn't want to continue the tenancy beyond that date. As one might suspect, non-payment proceedings are premised upon the failure of the tenant to pay rent timely. There's a strict procedure that a landlord has to follow to properly bring a non-payment proceeding. Some of these requirements seem, technical or procedural or minimal, but these requirements that we're about to go into, including some of the defenses that Jasmine will cover in her session, are really important, are really the bread and butter of these kind of actions. Frankly, many times in a non-payment case, the issue legally is whether they paid rent, but oftentimes that's not really an issue. The issue is more the things that I'm about to talk about now and whether the procedure, which is supposed to be strict, was actually followed. Under the new law, a landlord now must give a statutory grace period of 5 days, and after the 5 days is expired, under RPL section 235-ED, a 5-day written reminder has to be sent by certified mail, and it can't be served until after the rent is the 5 days late. So that notice is done after the 5 days expire. The next notice is done before the time period expires, and that's a rent demand, eviction notice, rent demand. It's got multiple names, but it used to be under the old law that required only 3 days to pay or vacate. Under the 2019 law, now that's 14 days, and it has to be served just like the notice of petition and petition do in accordance with RPAPL section 735. There are many issues that arise as a result of the rent demand, whether it be the timing, the content, and the service. And if you don't remember anything else of what I say today, when you're looking at notices, content, timing, and service are almost always the three things that you look at. Some of these are mentioned here. Must provide the tenant with actual notice that rent is being demanded and that the landlord will seek an eviction. It has to provide the tenant with the amount of rent allegedly due and the period of time covered by the amount. It really requires that the rent alleged to be owed be broken down. It can't be you owe $2,500 and pay it in 14 days, or move, or we're going to file for an eviction. It really has to say, you owe $300 for February of 2021, you owe $750 March, $750 April, and so on, with the total there. The idea being that the purpose of the rent demand is to allow, theoretically at least, the tenant to know what the landlord is claiming they owe, and if they agree with it, paying it to try to avoid litigation, or maybe it's a basis for them not to agree with it because they don't believe in the breakdown that's been given in the notice. The notice must be clear and unequivocal, and it has to say pay or quit within the 14 days. If it just says pay or I'm going to evict you, it's invalid. If it just says move within 14 days or I'm going to evict you, it's invalid. It has to pay or quit, and it has to be actually rent, which is another reason that the breakdown is important, because oftentimes landlords will try to include attorney's fees, late fees, service fees, filing fees, whatever other fees they can think of or that might be listed in their lease. So it has to just be rent, and it can't be brought, this is the timing part, until after the time to pay expires. If a petition is filed before the expiration of the 14 days in the rent demand, then that's a subject matter jurisdiction issue and is a case that should be dismissed by the court because they don't have the jurisdiction to entertain the petition. Next slide, please. This is just a sample of a rent demand. With the, it says it has 3 days and it also has 14 days. And the question is whether that's clear and unequivocal, because it says you have to pay within 13 days. And if you don't pay, you have to move within 14 days. So I think this could be subject to challenge. And the law isn't self-enforcing, so it's important for attorneys like you that are here today that are going to participate in the Attorney for the Day program to argue defenses like this. Would a judge dismiss a case based on that being an unclear notice? Maybe. Depends on the judge. Probably depends on maybe the other factors and what the lawsuit's about. So next slide, please. On to holdover proceedings. This is the other type based on expiration of the tenancy. The lease has to actually have ended or been terminated. The lease can terminate by operation of law. It also can be terminated by operation of a conditional limitation in the lease. If there's a written lease, there must be a provision authorizing such termination. The 2019 law has changed it so that before, if a lease just expired, say there's a 1-year written lease and then the landlord decided, I don't want to rent to this person anymore. Once the lease expired, as long as there was no further acceptance of rent or no further extension of the tenancy, you didn't even have to give notice. You could just file and you're in court and you're ready to go. Now you have to give notice prior to a certain number of days prior to the expiration of the lease, depending on the duration of the tenancy. So that's something that's a big change. And the tenant has to be in possession without permission past the expiration of the lease for a holdover proceeding to lie, which only makes sense. You can't maintain a holdover proceeding if the tenant isn't holding over. Next slide, please. The predicate notices that are required are different than the rent demand in a non-payment proceeding. Now, in virtually all circumstances where a landlord wants to set up a holdover proceeding, they have to serve a notice. The notices are required or governed by the terms of the lease and the RPAPL, especially, and also I think it's RPL 226C, which is a new provision that now governs what the notice has to be, how long. 30 days if you live there less than a year, and 60 days if you lived there between 1 and 2 years, and 90 days if it's been more than 2 years. I also think it's 60 days if you have had a lease for at least 1 year as well. So though it gets interesting because if there's different notices that's in the lease, and there's a conflict between the lease and the statute, it gets a little more complicated. How these notices are served is also governed by the lease and or by statute. Next slide, please. Thanks. The notice has to actually terminate the tenancy, notify the tenant of that termination, and that what's going to happen if they don't move out, which is that a summary proceeding will be commenced, or there'll be eviction proceeding in court, however they want to state it. The requirements governing a notice to terminate are generally governed by the terms of a lease, which admittedly in the attorney for the day context can be challenging, because if people have a viable lease, sometimes they'll bring them to court with them. Oftentimes they won't. And in the attorney for the day context, that makes it difficult because the lease is important. It governs the terms and obligations and conditions of the tenancy. So that's a difficulty that can come up. As far as the statute I was just talking about, well, 232B in the RPL allows a tenant to terminate upon giving 1 month's notice. The landlord to terminate, as I was just saying, 226C of the RPL requires a written notice of either 30, 60, or 90 days, depending on how long the tenant has occupied the premises, and if there's a written lease as well. This is a sample notice to terminate. Frankly, in looking at these, I didn't study these notices, but let's look at this one and see if there's anything wrong with it. It has to give a specific date that the tenancy will be terminated. This does on December 31st, 2018. It's dated November 29th, 2018, so it would have to be served before December 1st to be a valid 30-day notice. This would obviously only be valid for somebody who had lived there for less than a year in this context. Other than that, I mean, not having studied this word for word, it looks okay to me. Next. Okay, and on to the specifics of the predicate notices. We talked a little bit earlier about a non-tenant occupant like a licensee or a squatter gets 10 days notice, and that's governed by RPAPL section 713. It has to be 10 days. Again, the 10 days have to expire. If the petition's filed before the expiration of the 10 days, it's premature and deprives the court of jurisdiction. Have to be served in accordance with RPAPL 735. And that basically talks about personal service or substitute service. Is that something that you're going to talk about in your presentation, Jasmine? I'm sorry, I didn't study your slides.
Yep, I am. Okay,
so I'll gloss over that for now. It also need to state the facts upon which the notice is based. RPAPL 741 requires certain things to be in the petition, and one of them is, who's the petitioner and who's the respondent, and how do they relate to each other? Licensee, squatter, tenant under a written rental agreement, that all has to be laid out in the petition. And here's another sample of a 10-day notice, not the 30-day or the 14-day that we talked about before. And this is basically telling them that they have to be out by January 14th. It's January 3rd is what it's dated. I think if it was served then, or maybe the next day, I'd have to count the days, it would be okay. Obviously, if it was served on January 6th and only gave the tenant 8 days, I think that would be defective. Other than that, it basically says it's not a pay or quit notice. It's just a quit notice. It says you got to move out by that date, or we're going to commence an eviction proceeding to remove you and everybody else that's there. Predicate notices and notice to cure. We don't see this that much, except if the tenant does have their lease. And for any of you that are going to be handling cases outside of the attorney for the day context, you want to get the lease for sure. Hopefully in the attorney for the day context, they bring the lease to court, because the lease often will have different notice requirements than what the law has. And I believe that landlords are allowed to expand the notice requirements, but they're not allowed to restrict them. So the lease is important. And sometimes it has this notice to cure, and there really isn't much of a notice to cure in the law, except there's a notice to cure in breach of lease cases under RPAPL 753, where you can ask for a 30-day stay after you would lose an eviction case for breaching a lease. You get 30 days to cure, and then arguably you could bring an order to show cause and say, hey, I cured the violation, so wipe out the eviction. Other than that, it doesn't come up that much, except for when it's in the lease. And a lot of times leases will say, if you do X, Y, Z, A, B, C tenant, if you do any of these things, we're going to give you a 5-day notice or a 10-day notice to cure. And if you've cured it in that period, if you've gotten rid of the dog that's in violation of the lease, for example, you're good. If not, then we're going to give you a termination notice, and then it goes in and becomes a for-cause holdover for breaching the lease. The Yellowstone injunction, I've read about this, I've heard about it, I've seen it on slides like this. I've never seen it come into play, so I'm not going to spend much time on that, if any. It's there, that's the explanation of it. I don't see it much in practice. Okay, so to get down to the pleadings, once you've served your predicate notice, you've waited out the time period is expired, then it's time to commence the summary proceeding by filing a notice of petition and petition. As I stated earlier, the notice of petition is similar to a summons in any other civil case. It tells you, hey, you've been sued and you need to come to court on this date at this address. And here's what they're suing you for, and here's what you can do to protect your interests. So you can file an answer, appear, that kind of thing. Most of the time, the hearing date is filled in by hand. It has to specify the relief sought, and it also has to be signed or issued by a clerk of the court, a judge, or a lawyer. Sometimes landlords will sign notice of petition themselves, and if they're not lawyers, then that's a basis for dismissal. Petition is the document, it's what would be a complaint in other civil action. It states the basis for the eviction. Again, it lays out who the parties are and says what the landlord wants, claims, tenant breached the obligation in the rental agreement to pay rent, or we gave a termination notice and they haven't moved, and so we're doing a holdover, or they breached the lease in these ways, and because of that, we want to evict them in a for-cause holdover proceeding. The respondent, who's the tenant, can then file an answer. Oftentimes, judges will just allow tenants to give verbal answers at the initial appearance. Sometimes we do a verbal motion to dismiss in lieu of an answer, which we're permitted to do. Okay, now I think we're good. As I was saying earlier, the special proceeding is commenced by a petition and notice of petition, which can only be issued, meaning signed, by an attorney, judge, or clerk of the court, not by a party prosecuting the proceeding in person. Haven't seen that much in city courts, but in town and village courts out in the rural areas, landlords, pro se landlords signing notice of petitions is I don't know if it's prevalent, but I've seen it. I've seen it quite a few times in those cases. The Section 732 piece doesn't really apply here, and the provision in the first paragraph is set out by RPAPL Section 731. Okay. Sample notice of petition. This is what it looks like. Probably signed by a lawyer in this instance. This looks like a lawyer-generated petition. As you see, the court, the court or the landlord's attorney writes in the date and time of the initial appearance, and it also states the address of the court so that the respondent knows where to go, and basically lays out a little bit about what the case is about. As I mentioned before, 741 of the RPAPL sets out the minimum requirements for every petition. usually we don't see this, but recently we had a case where I don't know that we pursued this defense, or the case might have settled. I don't remember exactly, but it was a failure to state a claim, and it's the first time I'd ever seen it because the respondent's interest wasn't spelled out at all. It said who the petitioner was. It says there was a rental agreement, and it said 1, 3, 4, and 5, all those requirements. And I guess it could be implied because it talked about a rental agreement, but it didn't specifically say, the respondent herein was a tenant under this rental agreement or licensee or squatter or anything. So don't see that very often. Most petitions, especially by attorneys, knock all these out. But that one instance not too long ago, like I said, we saw one that was lacking. Under 741, the petition must be verified pursuant to CPLR 3020. We see pro se landlords and represented landlords mess this up all the time. The requirements of CPLR 3020 are fairly clear, but they're not always followed. Sometimes it happens where corporation, if they're the petitioner, it has to be verified by a corporate officer, and instead it's verified by an agent. But most commonly, for some reason, the attorney doesn't have the landlord or the petitioner or the owner of the property verify it, so the attorney verifies it, which can be okay in some circumstances, but the attorney is required to explain why they're verifying it. And we see, I would say, 1/3 of the time that these are not in accordance with the CPLR. It's also not a defense that most courts will dismiss on. In our experience, if there's no verification at all, that's a better argument for dismissal than if you've got a verification that's there but incorrect. And RPAPL 721 sets out the person specifically authorized to bring a summary proceeding. Noteworthy in that section is that the prior version of that section, which I think was a while ago, allowed agents to be petitioners and file on behalf of landlords. The current version, which is not very current, but it's the most recent one, does not allow that, doesn't allow agents to be petitioners in summary proceedings anymore. And here's a sample petition just to give you an idea what it looks like. Again, it's not dissimilar to a complaint in any other civil action, except it's usually shorter. You lay out who the people are, you meet the requirements of 741 that we just reviewed. You state the basis for your claim, you state what you want, you have the verification here, and boom, it's over. That's it. Pretty short usually. Methods of service. I know that Jasmine said she's going to cover this, so I'm going to kind of breeze past it quickly. It's 735 of the RPAPL governs this. A lot of cases are won or lost on service. We get cases dismissed, I wouldn't say all the time, but fairly regularly because the service wasn't done correctly, or it wasn't on a proper person, or the affidavit of service wasn't filled out correctly, or they didn't make the requisite number of attempts at personal service before they did substituted service. There are all kind of issues, and I think, like I said, Jasmine's going to get into more detail. The big takeaway, I guess, just from the global view that I'm giving you is that when the petition and notice of petition, or the notice, the predicate notice, whatever you're talking about, when it's served personally, the date of service is considered to be that day. When it's served by these various means of substituted service, it is determined to be complete on the day of the filing of the affidavit of service, which is a big difference. And it becomes important as to when service was achieved, because service has to be at least 10 to 17 days before the hearing date. So if the landlord kind of gets a quick hearing because they want to get them out, but then it takes them 3 or 4 days to get service accomplished, there could be a 1017 defense. That's what we call it. So it's important to determine how the person was served. Any case that you're analyzing in this realm, you have to ask for the affidavit for service, affidavit of service. the tenant won't have it. The court will, if there is one. And that's the other thing. If there is no affidavit of service, then that can be a basis for dismissal as well. Timing. I was just mentioning this. I've been ahead of myself on all of these slides. I don't know if that's good or bad, but in any event, 733 of the RPAPL requires that the notice of petition be served at least 10, but not more than 17 days before the initial appearance or the return date. That should be in red because it's new. It used to be 5 to 12 days. Now it's 10 to 17, which is frankly very helpful for us because the more time there is for the tenant to call us and go through our intake process and apply for assistance, the better. As I mentioned a minute ago, 735 personal services completed at the time of service, the various kinds of sub-services deemed complete when the affidavit of service is filed with the court. Answering the petition, RPAPL 743 details the rules for answering that need to be followed. You can answer verbally or in writing. Oftentimes when we go to court at an initial appearance and we say, Your Honor, we've got, some defenses that we'd like to preserve. Oftentimes they'll say, well, how about you file a written answer? We'll give you 14 days. It kind of happens that way. Again, though, you can, the answer can be verbal. It says the respondent must go to the clerk or presiding judge. That's not the way it usually happens. I think if you went to the clerk of the court of most courts and says, I want to give my answer, they'd probably look at you like you had 5 heads, but that's what the law says. Usually it happens in open court at the initial appearance. And you literally do a verbal answer, which is, admit paragraph number 1, deny paragraph number 2, and so on, just like if you were doing a written answer in any other civil case. And as I mentioned earlier, if you've got a basis for dismissal, you can do a verbal or written motion to dismiss in lieu of an answer. And the answer can contain any legal or equitable defense, and it can also contain counterclaims. It doesn't have to, but it can, and the tenant can ask for a monetary judgment based on the counterclaim or counterclaims. Again, defenses is going to be Jasmine's presentation, but just this is just the overview of, you've got procedural, some people call them technical defenses, like a lot of the ones we've talked about so far about, content of the notice and service and timing and those kind of procedural defenses. Those are really the most common defenses that we see. There are defenses to non-payment that are unique to non-payment, like payment. There are defenses that are unique to holdover, like acceptance of rent after the termination date and a holdover notice. The warranty of habitability. There are slides here that I'm really not going to cover that much because I think that's a good chunk of Jasmine's presentation. And then there's retaliation, which is the new law changed the requirements for retaliation and made them more tenant friendly. It's still a hard defense. It is a defense that is probably there less than half the time that the tenant might think it's there. But it is there, and it can also be a counterclaim in appropriate circumstances. Again, I'm going to kind of skip through these. I see that my time is running through, but you can look at these slides. These are the procedural defenses. Most of them we've talked about already. And again, these are going to be part of Jasmine's presentation. So why don't we can just skip through there. I think you might need to go back. Is that it? Okay. Hearings. What happens? And again, I know that I think that Vera probably will be talking a little bit more about this, about kind of what happens when you're there, an attorney for the day and things like that. But basically the initial appearance, it's strange. When I started out practicing in Amsterdam, and I would go to Amsterdam City Court every week to defend tenants and evictions, and you would go there, and I don't know if it's still this way. This is, at least a decade ago. You would go there and you'd settle the case, or you'd get it dismissed, or you'd get it adjourned. And if you didn't, boom, you have your contested hearing right now, right here. That's not the way that it's done in the city courts. You know, if you're doing attorney for the day in Troy City Court or Albany City Court, generally there's an initial appearance, again, to determine whether the case can be settled, whether it's adjourned, whether it's dismissed, or whether it's set for a trial date. Very rarely is there any testimony or evidence taken at an initial appearance. One of the parts of the new law is that if anybody raises a triable issue of fact, landlord says, you know, you owe 5 months rent. Tenant says, I paid all those months rent. I've got my receipts. Sounds like a triable issue of fact. If either party requests an adjournment, the court is required to adjourn it for at least 14 days. It used to be 10 days, and that's for the first adjournment. So it's kind of crucial if you're talking to a tenant and they say, I'm not ready, I need to ask for an adjournment, I've got to get this document, or I've got to pick up my children from their babysitter in 15 minutes, I can't stay here, whatever the reason is. If it's the second one or more, if it's not the first one, then it's within the court's discretion as to whether to grant the adjournment. So it's important, if you've got a client who you think needs an adjournment or they think they need an adjournment, it's important to determine whether they got an adjournment before, or whether they did, or whether they requested an adjournment before, I guess is more accurate. Because if they did, then it's within the court's discretion. And if they didn't, then you're entitled to it under the statute. So it really kind of depends on how you're going to argue that. Because if it's not the first one, all you can do is try to persuade the judge to exercise their discretion in the way that you want them to, or that is best for your client. If you can go back on that one. There are parties who can bring non-attorney, that should say non-attorney witnesses with them, such as legal advocates. I know sometimes United Tenants of Albany will come to court with people to assist them in Albany City Court. I think maybe Unity House advocates come sometimes in Troy. They're only supposed to be there in a supporting capacity, and it shouldn't be able to represent people on the record or be witnesses. But there is latitude, I think, that's given by different courts as far as allowing non-attorney advocates and whether they can participate in the process. If the judge rules against the tenant, these are the possible outcomes. You can get a written decision that lays out how the judge ruled. That's usually more common if there was a trial. Oftentimes in a trial, the judge won't issue a ruling from the bench, but will take some time to review their notes and do research or whatever, and then issue a written decision to all the parties. If there's not a trial and there's no issue of fact, then a judgment can just be issued that entails what the petitioner is entitled to, usually possession of the premises, that a warrant will issue or a monetary amount, and the warrant of eviction, which can be stayed to a later date. The warrant of eviction is issued by the court, and then it goes to a marshal or a sheriff for service. But the court has the discretion to delay enforcement or stay enforcement, and the parties have the ability to negotiate agreements that would involve the warrant of eviction being immediately issued but stayed until a certain date, or can be premised on the occurrence of a specific event. In other words, we're going to issue a warrant, but it's going to be stayed, and it will never be sent to the sheriff as long as the tenant pays $500 by next Friday, for example, something like that. So, or sometimes they're just straight up, it's a contested matter, there's no settlement, warrant of evictions issued, and then it goes into the warrant process. Trials, if the judge determines that there is a triable issue of fact, she can schedule it for a trial. Oftentimes it's week, 2 weeks, 3 weeks, really just depends on the schedule of the court and the attorneys involved, if both sides are represented by an attorney. The rules of evidence apply in a trial in these cases. It's really not different from a trial in any other civil case, except it's usually abbreviated. You know, I know that a lot of civil trials can last days and weeks. These usually last more like hours, like, you know, usually hour, 2, 3 hours. There can be, if there's a lot of defenses and a lot of witnesses, there can be trials that go longer than that. I think that's pretty uncommon though. And there is a tendency to, since it's a summary proceeding, for the courts to be fairly liberal about what evidence comes in. And I don't know for sure why that is. My guess would be that because it's a summary proceeding and it goes so quickly, you know, you don't have time, you know, you can't do discovery, you can't do depositions. If you're seeking medical documents or even documents from a third party, it's kind of hard to get them in the short time frame. So I think that's why courts are more liberal about evidence in that regard, just because it's hard to muster up a lot of tangible, you know, documentary or other kind of evidence in the short time frame that's involved in one of these proceedings. Remedies. Warrant of eviction as a tenant representative or tenant lawyer or advocate. This is, you know, what you're trying to prevent from happening generally. When it's been issued by the court, it goes to a law enforcement agency. In Albany, that would be the sheriff. In Troy, that would be the court marshal. Law enforcement has to serve it on the tenant. It can't be served by anyone else. And they have to serve it in accordance with 735 of the RPAPL. That doesn't happen sometimes. And I don't really know that there's a great remedy for it. Because under 735, if the tenant's not home, then they're into subservice and they can post it, but they have to do mail and all that kind of stuff, regular mail, certified mail. And when we used to call law enforcement on that, they would say, well, it's only 3 days. By the time we mail it, the tenant would probably be gone. Now it's 14 days. I think there was a recent third department case that I'm not 100% familiar with. I think that basically said that law enforcement not complying with 735 in that context was not a basis for the eviction to be set aside. I think that's what it said. But in any event, under the 2019 law, now the warrant has to state on its face the earliest date upon which execution can occur. And it can only be enforced against persons named in the proceeding, which is a change. It used to say, I don't remember exactly, it didn't say persons named in the proceeding. And that's important because if you've got 3 adults that live there and only one of them was named as a respondent, there's an argument that the other 2 can't be evicted by the sheriff when they come to serve and then enforce the warrant. This plays into a necessary party defense that I assume Jasmine will be talking about. You know, when if not all of the adults have been named and served, and you can establish that the landlord knew they were there, that provides you with the defense. And oftentimes it's something you can talk to the petitioner's attorney about. Say, do you want to go through this process and evict one of the 3 adults there? Or do you want to start over and get all of them out? Presumably that was the goal. So I don't know how that's really played out yet. Again, that's part of the 2019 law, but it's certainly a significant change. So what happens is the sheriff or marshal serves the warrant, and then at least 14 days later, they come back and they enforce the warrant, execute the warrant, which means they make everybody who was named in the proceeding leave. And oftentimes they will supervise the landlord removing the premise, removing the property. There are some things where like there's some ordinances in some cities that require landlords to store property for 30 days in this scenario. Some don't have that. The eviction warrant can only be served and executed on business days between sunrise and sunset, not on holidays or weekends.
All right, Bob, I am going to jump in and let you know you got 5 minutes left.
Okay, thank you. How many slides do I have left? What number am I on?
You're on 45.
Okay, thank you.
You have a particular one you want me to jump to or keep going?
We'll just keep going, see where we're at. Okay. This is the new amendments to RPAPL 749, which is what governs warrants of eviction. I won't hit on all these in the interest of time. I think it's important to note that the court has the ability to stay prior execution of the warrant or to restore possession to a tenant after execution of the warrant. It used to be that in order to file an order to show cause and get a warrant stayed, the statute said you had to do it before the warrant was executed. There were cases from New York City that some upstate judges followed and some didn't, that extended it beyond that. Now it's clear that the statute allows you to file an order to show cause even after the tenant has been removed. Okay, we'll keep going here. There can be money judgments in an eviction proceeding, usually judgment for unpaid rent. It says that they have to be limited to rent and not fees or charges or attorney's fees. I don't know that part of the new law has been universally applied. Actually, I think it probably hasn't. I think it's more that you can't be evicted for not paying anything but rent. But if there's a money judgment, oftentimes it will include fees and attorney's fees, although the new law is fairly clear that you can't get attorney's fees if the tenant defaults and doesn't appear. Negotiating settlements. This is the biggest part of what you'll do if you work for attorney for the day. If you have a few cases, you'll try to get dismissed. Cases may be adjourned or set for trial. Most of the cases are settled like anything else. Usually judges will want to know if you've had a chance to talk. So you should try to talk to the other side before your case is called by the court, if you can. If not, it's best to tell the court, we haven't really gotten a chance to talk. Can you recall our case? And almost every judge will say yes. They're often the best outcome for both parties. Oftentimes, the first thing to determine as a tenant's advocate or a tenant's attorney is, does the tenant want to stay or do they want to leave? And it's also important to determine what's more important, time or money. Sometimes tenants will say, my credit's shot anyway. I don't care if there's a money judgment, but I need 2 months to move out. Or some people will say, I'm moving to my mom's this weekend. I don't care about time, but I don't want to have a money judgment because I'm going to try to buy a house next year and I don't want my credit to be all messed up from that. So really, those are the kind of the threshold things. Do you want to stay? It's the old Clash song, should I stay or should I go? That's the first question. And then the second one is, are you worried about time or money? I guess they're not mutually exclusive. A tenant could want no money judgment and time. But those are kind of threshold issues. Just because you have a basis for dismissal doesn't mean that the best result would be a dismissal. Oftentimes, if a dismissal is obtained, the landlord can simply restart the process. They don't always, but a lot of times they can and do. So oftentimes it's best to identify a defense and use it as leverage to get a settlement that's favorable for the tenant. The landlords will agree to a lot of different things depending on if they're represented, and just a lot of times, frankly, it depends on the relationship between the landlord and the tenant. I think sometimes these cases are just one step down from divorces, especially for long-term tenancies. So if they like each other, it's a lot easier. If they don't, not as easy, which obviously makes sense. But a lot of times landlords will agree to waive back rent. They'll agree to an adjournment so the tenant can go to DSS, or nowadays can apply for ERAP so that the landlord can get the money. They'll agree to payment plans, extended time to vacate. Sometimes if the tenant is staying, landlords will even agree to lower the rent over a period of time in order to make it more manageable. If you got a tenant that got hurt at the job or is sick and they're on disability, but they're going to go back to work and maybe lower the rent for 3 months until they go back to work. It really is just limited by the creativity of the people that are negotiating the settlement.
All right, Bob, we have hit the 1 o'clock mark.
Okay, that's the new law. That's what it's called. And that's when it was enacted. Most of the protections are enacted on that date. I think that's the end of the slides anyway, right?
I think there was a little bit more on the actual.
Okay.
Oh, but They are in the materials that were circulated to everyone. And like I said earlier, if you registered late this morning, please feel free to shoot me an email and I will make sure that you get these materials by end of presentation today. And thank you, Bob, so much.
Sure.
All right, our next panelist today is another colleague of mine, Jasmine Greenfield. She is a graduate of Syracuse College of Law and joined LASNNY in 2019. She began her work as a housing attorney under the Solutions to End Homelessness program in the Amsterdam office. Since 2021, Jasmine is now the economic justice attorney, where she focuses on housing, public benefits, and unemployment claims. Jasmine also works closely with the Fulton County Office for the Aging, providing estate planning and other services to the Fulton County seniors.
All right, thank you, Mallory, and thank you, Bob. I have to follow up after Bob, so bear with me, it may be rough. So today we're just going to go over some of the common defenses that Bob just kind of glossed over during his presentation. So specifically, we're going to hit on the procedural defenses or the technical defenses, some specific non-payment defenses, holdover defenses, warranty of habitability, retaliation in conjunction with the warranty of habitability, and then I'll get into the COVID specific defenses that are currently applicable. Next slide, please. Okay, procedural defenses. So these apply across the board to every type of summary proceeding that's filed. And it's very important to know when a procedural defense applies, because the argument is, because this is a statutory, because a summary proceeding is a statutory creation, there must be strict compliance with the terms of the statute. And so if a landlord or a landlord's attorney says that, you know, what's the danger in not complying with the statute, it's that because of the creation of the statute, there must be strict compliance. So in the first one, improper service. So if service is not completed or it's done improperly, this must be raised at the very first appearance, or the respondent waives a right to a traverse hearing. A traverse hearing is a hearing to determine if service was properly attained, and that is in CPLR 3212. During that traverse hearing, the respondent has the burden of proof unless the affidavit of service is so deficient on its face that it's clear that service was not completed. So the time of service, this used to be called the 5 and 12 rule, but now it's called the 10 and 17 rule, giving tenants more time to know when they're going to court. It says that service upon the respondent must be completed no less than 10 and no more than 17 days prior to the court date in RPAPL 733. So there are 3 types of service in RPAPL. There's personal service, pretty easy, personally serving the respondent. Service on a person of suitable age and discretion. So it must be a person who resides at the premises and is over the age of 18. And the third one is mail and mail. So it's where the notice of petition and petition are taped to the door, and then a copy is sent by certified mail and first class mail to the respondent. In nail and mail service, personal service must be attempted at least twice before actually attempting a nail and mail, called due diligence. So when is service complete? For personal service, it's complete, as Bob said, at the time of service. And for the other 2, for suitable age and discretion, nail and mail, it's upon the filing of the affidavit with the court. Also, as standard in all cases, a party to the proceeding cannot serve any of the court documents. And also, it should be noted that each respondent gets their own copies of the papers, and therefore there should be affidavits for each of the persons who are being served. And so it is completely possible that one respondent gets personally served, whereas another respondent because whoever accepted service when they were personally served, they get served as a person of suitable age and discretion. Let's see, just to make sure I'm not forgetting anything here. These requirements, they under RPAPL 733, they are required for 14-day rent demands and the notices to quit as well, or the 30-day notices of termination as they're typically known. Next slide, please. So improper court, subject matter jurisdiction. This is non-waivable. A tenant, the premises must be located within the jurisdiction of the court. That's usually one of the major ways that it comes up. And the other way that the defense comes up is if the core of the dispute is not actually appropriate for a summary proceeding. So the relationship between the two parties must be delineated in 711 and 713 of RPAPL. And so if they have a land contract, and it's usually a land contract where if the parties default, it doesn't specify that they're now in a landlord-tenant relationship, or if the respondent is no longer in possession, and thus possession can no longer be sought. So if in that situation, if the landlord is only seeking a money judgment, it's much better to be in a plenary action rather than a summary proceeding. Next slide, please. All right, improper petitioner. So this is in RPAPL 711, 13, and 21. So only the persons described in those statutes have the standing to maintain a summary proceeding. So that means the landlord or the property owner. And if it's not the property owner and it's somebody else, they have to show the ability to transfer possession, to not only transfer possession, but also the authority to enter into a contract. So the person with standing and that person alone may maintain the summary proceeding in their name, not an agent, not the person's husband or wife, not their attorney. It must be the owner or the landlord. If they fail to name their proper party, so let's say if it's an LLC that owns the property and it's actually being brought in the owner of the LLC's name, then that is not amenable and it should be dismissed. As well, defective verification, Bob hit on this. So CPLR 3020 sets what must be stated in that verification. And it, if it's missing entirely, like Bob said, it's usually a much better case to get it dismissed. And if you are alleging that it is improperly verified or it's not verified at all, it is treated as a nullity only upon notice to the petitioner or the petitioner's attorney. So typically this probably wouldn't come up in a attorney for the day situation, just because you don't have an opportunity to send notice. But what I typically do is I send a letter to the petitioner or the petitioner's attorney that I am going to treat it as a nullity unless and until you properly verify it. Let's see. Yep, next slide, please. All right. Failure to plead. So 741 specifies specifically what you must state in your petition in order for it to be accurate and accepted. So you must state their interest in the property. The petitioner's interest in the property, I should say, must state the respondent's interest in the property and the relationship between petitioner and respondent. And it also must state a description of the subject premises, so like the address. Sometimes it says like, and all rooms or the 6 rooms of the premises at this address. It also must state the facts upon which the summary proceeding is based, and also the relief sought, such as a judgment and possession. So many landlords, they use these form documents that they just fill in these options. And the biggest miss usually for landlords is the facts upon which the summary proceeding is based. So they usually leave it blank, or they fail to put into that section that they served like a 14-day rent demand or a notice of termination on the tenants. And so if they forget to do that, it's a good basis to get the petition dismissed. Let's see, a failure to plead any of these conditions is grounds to have it dismissed, and all of the information must be accurate. There's also instances where the landlord prematurely files the petition. So it's before expiration of the 14-day rent demand or the notice of termination. So if they're allowed 60 days and the petitioner files on the 59th day, it's a premature filing and the petition should be dismissed. The other two instances that this would come up, a failure to serve a necessary party and to plead a necessary party. So like Bob said, where there's two tenants who have a lease at this property, you can state that other tenant also has an independent possessory interest to this property, and therefore they should be brought into this case and they're necessary to this case. I've also seen it come up where a landlord just pleads the wife or just the husband, and they don't plead the spouse. And so I often bring it up that they are a necessary party to this proceeding. I also always counsel clients that by adding this person, especially if it's their husband or wife or spouse, that there is the worry that that person can be evicted and that they could be subject to a judgment if they are added to the proceeding. And then the final instance in which it comes up is if it's a Section 8 tenant. If it's a person with a Section 8 housing choice voucher, the landlord is required as part of the contract with the Section 8 Public Housing Authority to plead and serve all of the documents on the Section 8 office. So if there is no description within the petition that says that this person is a Section 8 voucher holder, and there's no either affidavits of service or it's not alleged within the petition that they have served and given these copies to the Section 8 office, then this petition must be dismissed. Next slide, please. The final procedural one is, I guess it's more related to non-payment, but it is payment in a non-payment proceeding. So because a non-payment proceeding, the entire basis of the proceeding is the non-payment of rent. If a tenant pays the rent, then the proceeding must be dismissed. So it generally comes up in three instances where the respondent has paid the rent in full, or the respondent has tendered the payment to the petitioner, but the petitioner refused the rent, but this doesn't dismiss the respondent's obligation to pay the rent. They still have to pay the rent. And third, it's where the respondent pays the rent and the court costs at any time before or during the proceeding. So that includes up until the sheriff or the marshal comes to execute that warrant of eviction. So if at any point the respondent attempts to pay or pays the rent, then the proceeding should be vacated and dismissed. So this also includes, this was some of the amendments in 2019. It also includes if anyone or any agency on the tenant's behalf pays the full amount due, then the summary proceeding is moot. This often comes up as source of income discrimination. So landlords cannot refuse the payment based on source. So that includes DSS, ERAP, for instance, now. Catholic Charities usually makes payments, and pretty much any other organization that says that they will pay the full amount the landlord cannot refuse that. If it comes up, and I actually had a case where it did come up, and my client went to DSS. DSS tried to pay the full amount, and landlord refused it, and DSS put on the notice, we would pay your rent, but your landlord will not accept it. And so I filed that in my motion to dismiss, and I also reported the source of income discrimination with the AG's office, and I put in a copy of my complaint to the AG's office as a exhibit in my motion to dismiss. Generally, the courts will accept a promise of payment by agencies. The courts, they really recognize that those agencies are good for the money. And even if a landlord refuses, proper evidence to the court will render a proceeding moot, and the decision will be in favor of the tenant. Next slide, please.
Okay, everyone, we have our first CLE certificate code. So if your screen is minimized temporarily, of course, you might want to bring it up real quick so you can see, but the code is celebrate. So the first CLE code is celebrate. And like I said, I will announce them all again at the end, but the first one is celebrate. Sorry, go on, Jasmine.
All right. Excuse me. Okay, are we able to go to the next slide, or do you want to wait for a second? All right, non-payment specifically. So as Bob mentioned before, for non-payment cases to be commenced, you must first have a 5-day rent reminder that rent has not been paid. And then you must have a rent demand as well. So for the 5-day reminder, that's an RPL 235E. It must be in writing. It must be mailed to the tenant by certified mail and sent after the rent is at least 5 days past due. So rent is not late until after the 5th of the month. For the rent demand, it must be in writing, give at least 14 days, and it must be served in accordance with RPAPL 735. So it has to be served in the same manner as a notice of petition and petition. So arguably by a non-party to the proceeding, somebody over the age of 18, and it must be either personally served, left with a person of suitable age and discretion, or upon due diligence by mail-in mail. If there's a lease with that governs the relationship, it may require stricter service rules, but not more relaxed. So RPAPL is the baseline, and anything stricter than that, then they must conform with it. The petitioner must also plead and prove that they served the demand for rent, and a failure to do either is grounds for dismissal. I have seen it where it, not to be confused, is the 5-day reminder and the 14-day rent demand are completely separate things. However, the landlord could serve them concurrently. So the 5-day reminder could be sent in the mail on the same day that the tenant is actually served with a 14-day rent demand. And I have also seen some case law where they allow them to be on the same document. So it does say like 5-day reminder of rent, and oh, by the way, this is also your 14-day rent demand. So it's a little confusing, but those 5-day reminder letters are rather new. They were created in the Housing and Tenant Protection Act of 2019. For rent demands contained within the rent demand, it must be clear and unequivocal. It must itemize the amount of rent claimed with the months itemized. So June 2021, $750. July 2021, you owe $500, and it just has to be very clear to the tenant how much is owed. It also must be signed by the landlord or someone with the authority that the tenant recognizes as their landlord. So like a property manager, I've sometimes seen it where maybe the wife as the agent of the landlord can sign it. So in the fastest scenario, say rent is due on the 1st of the month. And then on the 6th, the landlord sends a certified reminder letter. And on the 6th, the landlord can also begin the attempts of personal service of the 14-day rent demand. And so in that event, the tenant would get the 14-day before the 5-day reminder letter. And then finally, extra charges. Summary proceedings for non-payment of rent, they can only be based on the non-payment of rent, not any extra charges. So no utility charges, late fees, or attorney's fees. You can't be evicted for those. Further, you can't be evicted for non-payment of a security deposit. Sometimes tenants move in where they're making, payments towards a security deposit every month because they don't have the full amount when they move in. Those non-payments cannot be the basis of a non-payment summary proceeding, just rent. All right, so a lack of a residential occupancy permit, this is within Albany specifically. It's in Albany City Code, section 231-131. Now, I will admit that I'm not the most familiar with that because I don't practice in Albany City Court. But it basically says that you cannot collect rents during any period of non-compliance with the residential occupancy permit. And then the lack of the permit is a basis for dismissal of a non-payment case. So I believe there's a way to look these up. I'm not entirely sure. I think, Bob, you might know a little bit better than I do if you can look them up, if there's like a database out there.
It used to be that there was, or that we could get it from code enforcement pretty reliably, even as late as the morning of the hearing, but that's not as easy as it used to be. There's also a statewide law on this now that is, I don't think really been argued that much that I know about. But I guess the bottom line in Albany is if you can prove there's no ROP, then the court will dismiss the case for lack of an ROP.
Awesome. All right, next slide, please. So holdover defenses. So to begin with, there is the failure to provide a proper termination notice. So the landlord must now adhere to real property law 226-C for the termination notice. So this is new. It states that this is basically the 30, 60, 90-day rule. So if a tenant has lived there less than a year, they get 30 days notice. If they've lived there between 1 and 2 years, they get 60 days notice. And if they've lived there for more than 2 years, they get 90 days of a termination notice. This notice must be clear and unambiguous, and it must state the last day of the tenancy. So it must state October 31st is the last day you're allowed to be here. If in some instances where it comes up, if the term has not expired. So if the rental term is not properly terminated, or it's not yet expired, or the lease term expired after the proceeding had been filed, the proceedings should be dismissed. If the landlord fails to provide the proper notice under 226C, then the tenancy continues until proper notice is given and that notice expires. So an improper notice means the tenancy is not terminated and there is not, there's no basis for the holdover proceeding. A couple other instances are violations of the lease. Only if the lease contains a clause allowing a termination by exercising the right to terminate and providing the tenant with a notice to cure and/or a notice to terminate. So the termination must state which lease provision is violated if it's being based on lease violations. All right, next slide, please. All right, acceptance of rent. So this is generally within the window period. So if the tenancy is terminated and the landlord accepts rent prior to the initiation of the summary proceeding, and it's for a period in between the termination and the initiation of the summary proceeding, then the acceptance of rent begins a new tenancy. This does not hold true if the tenant is paying for arrears. So if they owe for July rent and their tenancy expires at the end of July, and then the landlord commences the proceeding like August 15th, the tenant can't turn around and say that they paid August rent, as long as it's not earmarked as August rent, if they're only paying the arrears. Acceptance of the payment of arrears does not restart the tenancy. And there's also one other instance where if they enter into a new lease after termination, I've seen it where the property manager and the landlord weren't really speaking to each other apparently, and the property manager entered into a new lease with the petitioner while the landlord was trying, or with the respondent, while the landlord was trying to get them out as a holdover. So if they enter into a new lease, it's pretty unequivocal. They have restarted the tenancy. Objectionable tenancies. So these aren't applicable to tenancies without leases. You can only be an objectionable tenant if there's a lease. Leases must specifically authorize the termination of a lease upon the violation of the lease term. And the tenant is entitled to whatever notices is required by the lease. And if there's none, then they're entitled to a termination notice. So they get a 30, 60, or 90 days. Neither the lease term nor its violation can violate public policy and still be grounds for eviction. So it can't be something that restricts a person's ability to have a candle or something, something you're allowed to have as a person. It can't violate public policy. Landlord also has the duty to prove that the violation actually existed, and arguably there might be the ability to cure it, especially with that 30-day stay that Bob talked about earlier. Next slide, please. Oh, I should say on the last slide, typical causes for a objectionable tenancy. It's usually like creating or keeping too much trash on the premises, causing waste to the premises, violations of the rules of conduct, or drug or criminal activity. All right, warranty of habitability. So in every written or oral lease or rental agreement for residential premises, the landlord or lessor shall be deemed to covenant and warrant that the premises so leased or rented and all areas used in connection therewith in common with other tenants or residents are, and I wrote these down, fit for human habitation, for the uses reasonably intended by the parties, and that the occupants of such premises would not be subjected to any conditions which would be dangerous, hazardous, or detrimental to their life, health, or safety. And that's an RPL 235B. Next slide. So warranty of habitability can be raised as a defense in either a non-payment or a holdover. It can be used to offset a rent withholding in a non-payment defense, and it can be used to contest the rent that may be owed as use and occupancy in a holdover case. It's also can be used as a defense for in relation to retaliation in a holdover case. It can also be used as or raised as a counterclaim, and it's advised to raise both of them. So that way, if the petition is dismissed, the counterclaim for warranty of habitability survives. It should also be noted that even if the tenant is continuing to pay rent, it is not a waiver of the counterclaim of warranty of habitability. One of the big things that tenants often don't do is they often don't give their landlords actual notice of the conditions. So the landlord must have either actual notice or constructive notice. And usually constructive notice is, let's say, The landlord's at the property all the time. The windows are broken out. The landlord should be able to see that the windows are broken out in the front. So it's presumed that they know. Rent, if a court finds that the warranty of habitability was breached, the court will then determine what percentage of the value of the rental was lost. So the tenant is then entitled to an abatement of rent equal to that percentage that can be used to offset the amount owned or as damages to the tenant. So what the tenant needs to prove to win a warranty of habitability defense, they need to prove the existence of the conditions, that the landlord knew of the conditions and made no attempts to repair it, and the rental value of the premises given the existence of the conditions. Now, often, at least from what I've seen out in Amsterdam, a warranty of habitability defense doesn't prevent a tenant from paying rent entirely. It usually just offsets the amount of rent. And so the best thing that the tenant must do is they have to hold on to all of the rent and they cannot spend it. And it's only upon the determination of the judge saying, here's how much you actually owe for these months, or here's how much your rent is abated for each of these months, that the tenant is able to get that money and as their own as an abatement. So next slide, please. So just breaking these down with some case law. So the warranty of habitability, first prong, it must be fit for human habitation. And the Court of Appeals has determined that if the multiple residence law 174 is violated, it provides a bright line rule that the first prong of warranty of habitability has been breached. So MRL 174, that's the rule that the premises have to be kept in good repair, free from vermin, dirt, garbage, etc. Anything that makes the matter dangerous to the life or health. The premises must also be for the uses reasonably intended by the parties. So that usually protects against conditions that, while they don't render the apartment unsafe or uninhabitable, they constitute deficiencies that prevent the premises from serving their intended function of residential occupation. So that's usually like mold, the toilet doesn't work, the stove is broken, those sorts of things. That has to be pled. If you're pleading it as a counterclaim, it has to be pled with specificity, and the conditions specifically cannot be caused by the tenant. And finally, for the third prong, it shall not be subjected to any conditions which would be dangerous, hazardous, or detrimental to their life, health, or safety. So the appellate division found that tap water with a sickening, offensive odor violated this prong of the warranty. So some typical breaches that we usually see: safety concerns such as doors and windows that don't lock, mold, unsafe drinking water, leaks through the roof or ceiling, unsafe walls or ceilings, cracks, holes, foundation is cracking, and sewage issues. Usually when I'm doing my initial intake with a client, I ask them, what's wrong with the property? Do you have bed bugs, cockroaches? Are you able to lock the door? All of these things that I go through with them, and then I can kind of make a determination. Okay, how bad is this? And is this a possible warranty of habitability claim that I can make? Next slide, please. So I mentioned it a little bit earlier, but one of the options that a tenant has when there is a possible breach of warranty of habitability is withholding rent. So when the tenant alleges that the landlord has failed to make the repairs, the tenant can withhold the rent to motivate the landlord to make those repairs. Now, I always caution my tenants that this is the #1 way that you could be evicted, is by withholding your rent. So I always give them very, very specific instructions on what to do to properly withhold it. So ideally, what they need to do is provide notice to the landlord that the tenant is invoking or plans to invoke this right to repair until the repairs are made. So the tenant must put the money aside so that if the landlord does make those repairs, and should a judge determine that the tenant owes the rent, the tenant can immediately tender the payment. And then, most importantly, the tenant must allow the landlord access to make repairs if the landlord is actually going to make those repairs. The final one on there that's Social Services Law 143-B, also known as the Spiegel Act. It allows public welfare officials to withhold rental assistance in the event of habitability violations, and the tenant can't be held accountable for the rent that's being withheld by DSS. So this is in instances where the tenant is receiving public assistance payments that are being paid directly to the landlord. If DSS finds out that there are code violations and it violates the warranty of habitability, then they can withhold the payment, and the tenant can't be evicted for those withheld payments. All right. The next thing that a tenant could do, they could repair and deduct. So if a landlord fails to make the timely repairs, the tenant can decide to repair them themselves. However, they also, along with telling the landlord that they're withholding rent, they also have to tell the landlord that that they plan on making the repairs themselves. And then when the tenant goes to pay their rent for the next month, they can deduct the cost of those repairs from their rent. Timely repairs, it depends, is it a threat to safety and security? Is it an emergency? What needs to be taken care of? So that notice period may be shorter regarding the severity of the repair that needs to be made. And then a repair and deduct, much like warranty of habitability, it can be a counterclaim as well as an affirmative defense. And then constructive eviction. So a tenant must vacate the premises. This is where they must actually vacate. Where a tenant vacates the premises, since it's become completely uninhabitable due to the inaction of a landlord to make repairs or maintain the property, the tenant is excused from their obligation to pay rent. So if they actually leave the property and the court determines that the place is so uninhabitable, such as where perhaps code has condemned the place, that's a constructive eviction. The tenant isn't liable for those months of rent. All right, retaliation. So this is in conjunction with the warranty of habitability. So if a tenant makes a good faith complaint on or by or on behalf of the tenant to the landlord's agent, or a governmental agency of health or safety violations or the breach of warranty of habitability under RPL 235B, or the duty to repair under the multiple dwelling/residence law. So they cannot be retaliated with for making a good faith complaint. They also can't be retaliated against for taking action to enforce their rights under the lease or under the warranty of habitability, such as the duty to repair. And they also can't be retaliated for participating in a tenant's organization. There is a rebuttable presumption of retaliation if the eviction is brought within 1 year. This is new. I believe it used to be like 6 months. But now if there's a presumption of retaliation, if the eviction is brought within 1 year after the tenant's performance or participation in any of the above. And the burden is on the landlord to establish a non-retaliatory motive by preponderance of the evidence to overcome the presumption. So usually what happens is they'll say, well, it's not because they reported me to code, it's because they didn't pay rent, or it's because of some other issue, that the cops called too many times or something like that. Retaliation, it does not apply if the tenant causes the problem or to owner occupied 2 or 3 family residences. In addition to evictions, retaliatory actions also include unreasonable rent increases or substantial and unjust alterations to the rental agreement. If the landlord is found to have acted in retaliation, the tenant may seek treble damages and attorney's fees to defend against the retaliation. Next slide, please. All right, COVID defenses, the bread and butter of all of this. In case you have not been paying attention to any housing court or eviction proceedings during COVID, there's a current eviction moratorium going on in New York State, and that is extended until January 15th, 2022. Now, just because there is an eviction moratorium does not mean that tenants are unable to be evicted. In fact, they are being evicted, and they're quite frequently they are being evicted, actually. So the very first thing that I wanted to go over are these hardship declarations. The hardship declarations state that a tenant has experienced a hardship during COVID-19. So it can be basically anything. It can be a financial hardship, such as they lost their job or they had a reduction in hours. They experienced increased medical bills during COVID-19. They had increased childcare expenses during COVID-19. Pretty much anything and everything that you can think of that might have affected their ability to pay rent can be used as a hardship. And it used to be delineated in the old hardship declarations, but I don't believe it's delineated now. But the hardship declarations apply to all the proceedings, even those filed on or before March 7th in 2020. And if they are filed, it should stay the proceeding through January 15th, 2022. So this hardship declaration, it must be served with the rent demand or any other written notice required by the lease, a law or rule prior to the commencement of the proceeding, and with every notice of petition. No court should accept the filing of the petition or any other commencement papers in an eviction unless those papers include an affidavit of service and an affidavit attesting that at the time of the filing, neither the petitioner nor his or her or its agent has received a copy of a hardship declaration from respondent, or that the respondent has engaged in persistent and unreasonable behavior that substantially infringes on the use and enjoyment of the premises by other tenants, occupants, or causes a substantial safety hazard to others with a specific description of the behavior alleged, or that the petitioner believes in good faith that the hardship certified in the declaration does not exist. So in that third instance, that's where a respondent has already filed a hardship declaration with the court. Next slide. Going on the hardship declarations. So filing a declaration creates a rebuttable presumption that the tenant is experiencing a financial hardship. And now with the recent changes to the COVID-19 Emergency Eviction and Foreclosure Prevention Act, that's that CEEFPA that I have listed up there. With the recent changes to it, it's much easier for a landlord to contest its validity, and courts, if a landlord or their attorney contests the validity of it, they can schedule it for a hearing. At the outset of the proceeding, that's before the very first appearance, a petitioner is required to provide the respondent with a notice of contesting the certified hardship by serving a copy of the affidavit with the notice of petition. And then the court must provide notice to a respondent that the petitioner is challenging their certified hardship, and then they schedule a hearing on the declaration's validity. In the middle of a pending proceeding, so this is maybe at the first appearance, maybe the respondent showed up and decided to file their hardship declaration, and the petitioner objects to it. So the petitioner can make a motion on notice to the respondent saying that they have a good faith belief that the respondent has not experienced a certified hardship. And the results, if a court goes through a hardship hearing on its validity, if the court determines that the tenant does indeed have a COVID-19 hardship, It is required to stay the proceedings through January 15th, and it must direct the respondent to apply for rental assistance. So ERAP, DSS, any other rental assistance that's out there. And if it's invalid, the proceeding continues on its normal course. So any other defenses that may apply. Next slide. All right. The Emergency Rental Assistance Program, or ERAP, this was created within the 2021 New York State budget. I have the citation there. That's to the budget and the specific parts of it. And then Judge Lawrence Marks, he issued these AOs, specifically AO Administrative Order 245-21 and the accompanying memoranda with it. ERAP, it applies to holdover, expired lease, and non-payment of rent or utilities. If a tenant applies prior to the commencement of the action, the proceeding cannot be commenced against a household if it's applied for the program unless and until a determination on the application is made. And if an application is filed after commencement, the proceeding must be stayed until there's a determination on the application. Next slide. So if a landlord goes through the program and actually accepts a payment from it, and people are being paid, it creates a presumption that the tenant's rental obligation for the time period covered by the payment is fully satisfied. And that means that the proceeding cannot continue. The acceptance of the payment constitutes an agreement that the arrears covered by the program are satisfied, and it will not be used as the basis for a non-payment eviction. There's a waiver of all late fees. They cannot increase rent for 1 year, and they can't evict the tenant by reason of expired lease or holdover for 12 months after the receipt of the first payment, unless it's a dwelling unit of 4 or fewer units. So that means that if a tenant defaults in the payment of rent, after accepting the payment, so for like the next month, then they can be evicted for that non-payment of rent. So refusal to participate in the program. Hold on one moment. Sorry, I have to go really quickly. I apologize.
Jilliane is covering ERAP if you want to skip over it, Jasmine.
Yeah, I will skip over. Well, I will be right back. I really apologize, everyone.
Okay.
I apologize.
I can fill a little gap here if you want to, Mallory. I can talk about this stuff a little bit.
That would be appreciated.
The one thing about ERAP that I want to point out is that there are some judges and landlords lawyers who maintain and insist that the stay provided by ERAP and the pending ERAP application does not apply in holdover cases, and it's just wrong. The statute says holdover, non-payment, or expiration of lease. So I want to point that out. That it applies to all of them, and then you'll hear, well, this isn't about the money, the landlord doesn't want the money. Does it matter? Shouldn't matter. If there's an ERAP application pending, that should be a stay on the proceeding, hard stop, period. I don't know that that's happening. I know it's not happening universally, but that's just something that I wanted to stress. The other thing that we've seen is what happens when there's an ERAP application pending and you've got to stay, and then somebody wants a hardship hearing because they want to challenge the hardship declaration. And what is the interplay between an ERAP stay and a hardship hearing? We argue that the ERAP stay wins for various reasons, and Jasmine's back, and so my filibuster's over.
Sorry about that.
I was going to start going through the questions because we do have several questions. So.
Yeah. Okay. So Bob, you were talking about nuisance. I guess I will briefly go over it.
And Jilliane, are we touching on stuff that you plan on talking on?
Oh, is she? Oh, is she going?
Yes, I'll be covering the ERAP program, but
okay.
you know,
Sorry.
in more depth.
Okay. All right, then questions.
Did you want to touch on this one? This is the last slide, I think, before we had.
Oh, and there is one slide here on the Tenant Safe Harbor Act. This is specific for evictions for COVID-19 related hardships for non-payment of rent during the COVID-19 covered period. And so within one of the Judge Mark's AOs, he mentions that from March 7th, 2020 to June 24th, 2021, that's the covered period. So no court can issue a warrant of eviction or a possessory judgment against a tenant who suffered a financial hardship during that period. It, however, does not prevent a court from awarding a money judgment.
All right. Thank you, Jasmine. So now we do have some time for questions, and we do have a couple that have already been sent in through into us. I think the first one that came in, and I'll just read it out loud, says that they're interested in getting some input from the panel on RPL 235F, commonly known as the roommate law. I have not seen this statute addressed and have not been able to get a clear picture on its interpretation by the courts in New York. What are the kinds of unlawful limitations on occupancy that landlords can impose, which would violate this statute? Thank you.
Well, as discussed earlier, Bob.
Well, the one thing I can say is that I guess the low-hanging fruit on that last question is what kind of restrictions can a landlord impose that violate the statute? If they say the only people that can live there are the ones that are on the lease agreement, then that would be a clear violation of the roommate law, since it allows immediate family and one other person. So that's a pretty straightforward, simple answer to that question. If you try to restrict it, if the landlord tries to restrict the occupants to be more narrow than what the roommate law allows, then obviously that violates the roommate law.
All right, thank you, guys. One of the next questions is, does the 5-day reminder have to be sent for each month rent is late? I have always argued that it has and have had success with this.
I mean, I don't think the statute is very clear, and I don't think that it's not necessarily a jurisdictional defect unless you argue it as the legislative intent of it should be, that it's required for every single month. Arguably, from an advocate standpoint, you should argue that it's required for every single month that the rent is late. Yeah, any other thoughts from anybody else?
Going twice.
I'm just looking at the statute now that I have here, and it's not clear. I think that's an argument that can be made, but I don't know that it's anywhere near a slam dunk. If you've been arguing it and having had success with it, and you have written decisions, send them to one of us, because I'd love to see them so we could use them.
And then another one is landlords are frequently claiming that tenants are nuisance tenants based on multiple small infractions of leases. What are the notice requirements?
I think that's a forward answer, right? Depends on the lease.
Yeah, that's exactly what I was going to say. So if the lease requires that there's a notice to cure, or that, like for instance, in Section 8 tenants, there's usually like minor infractions can add up to a major violation and material noncompliance with the lease, that those minor infractions can constitute the ability to terminate the lease. And depending on how your lease is structured, you could be entitled to a 10-day or longer period of a notice to cure, or you could only be entitled to the RPAPL or RPL requirements of like a notice to termination for lease violations.
Thank you. There is a question that was sent to us, panelists, that I feel like centers more on ERAP. And so to the person who asked that question, I'm going to hold off on answering or asking it to the panel until we get done with Jillian's presentation, which is coming up next after our break. But then we do have a couple more. Does a proceeding brought in a month-to-month proceeding that is triggered by a clear DV event give a tenant any protection?
VAWA would probably apply. Without looking at the specifics of the Violence Against Women Act, I'm unsure. But
As well as the human
yeah.
rights law. There's protection in housing for victims of domestic violence.
I think it's like RPL 227, something like that. It says that can't be evicted if it's based on the tenant being a victim of domestic violence. Like, for example, if a tenant is being abused and they call the police a bunch of times, that can't be the basis for an eviction. I don't know that we've ever argued that, but it's there for sure. And VAWA, although VAWA I think only applies to like when you're getting federal funding. I think the state law would apply across the board.
All right, and then one more question before we go into our first break. If your lease stipulates that you need to inform landlord of someone moving in and you fail to do so, does that violate the roommate law?
I'm not a roommate law expert, but I would think that there could be an argument made that it's not, that it doesn't, because the eviction isn't because the person lives there. It's because you breached the provision in the lease, failing to inform the landlord that the person lives there. That's my initial thought. I've never thought about that question in my entire life, but that's what popped in my head.
Okay. All right. Well, thank you, everyone. We have hit our first 15-minute break. We are perfectly at 2 o'clock as soon as I finish my little spiel right now. So we will reconvene in 15 minutes at 2:15. See you all back here in a few. Oh, and to those of you who emailed me saying that you registered late this morning, I'm going to try and get to as many of you as I can and get you those materials before we start back up at 2:15. If I don't get it to you during this one, I'll try and get it to you during the next break. Thanks, everyone. All right, everyone, just in case you're away from your computers, you're probably going to get started in about a minute or so. And I have gotten several questions from attendees asking about the CLE course code, I guess, that shows on your attorney affirmation page, right above where you'll write in the code words that were showing throughout the screen or throughout the presentation. I apologize. That is internal use only, so don't worry about filling that out. That is something that we handle on our end of things. All you need to worry about is the code words that we will be presenting throughout the presentation. And if you missed the first one, it was celebrate. So I think with that, we are at 2:15 and we can probably go on and get started. Our next panelist is Jilliane Faison. Jilliane is an attorney from the Hudson Valley that has worked in human services and public interest law for the majority of her career. Ms. Faison graduated from SUNY Albany with a degree in political science from the Rockefeller College of Public Affairs and Policy and Penn State Dickinson School of Law with a concentration in refugee and immigration issues. The central theme of Ms. Faison's resume is a focus on working with and on behalf of underserved communities. Ms. Faison has worked in direct service refugee settlement, as a legislative advocate for harm reduction and housing justice, as a prosecutor that implemented restorative justice programs for juveniles, and as a government attorney at the state level, managing the legal departments of the 6 human service and mental hygiene state agencies in New York. Currently, Ms. Faison is the Deputy Commissioner for Policy and External Relations at the New York State Division of Human Rights. So welcome and thank you so much, Jilliane. And she will be talking.
Thank you so much. Yep, can everybody hear me? We're all good, okay. Thank you so much for having me. I'm really happy to talk to you all today about the Emergency Rental Assistance Program. You know, a caveat that I am not a landlord tenant expert. I really come to the subject from the standpoint of public benefits, because I was working before the Division of Human Rights. I was assistant counsel to the governor for human services, mental hygiene, and nonprofits. And so during the 2021-22 enacted budget or budget negotiations, we had the task of putting together the Emergency Rental Assistance Program statute and negotiating that to agreement, and then the very large job of rolling out the initiative in the state of New York. So that's where I come to this information and understanding from in terms of standpoint. And, you know, I did move on from the office before the second round of changes were negotiated as a part of the eviction moratorium revamp. So I'm just going to be talking about really the letter of the law in that respect. So what we're going to be talking about today in terms of the overview, the origins of the ERAP program, the main provisions, the changes, and then the associated laws and housing assistance programs that interface in various ways with ERAP. So I think we all are well aware of the devastating effects of the COVID-19 pandemic, especially on affordable housing. And the federal government, in its wisdom, did put together massive packages of assistance for states to administer rental assistance programs for households that were in significant arrears and facing eviction. So the first Emergency Rental Assistance Program distributed $25 billion through the Consolidated Appropriations Act. And then we call it ERA. ERA 2 provided $21.55 billion through the American Rescue Plan. So out of that, many, many billions of dollars, New York State received $1.28 billion in ERA 1 and $1.6 billion in ERA 2 for an approximately, it's really $2.35 billion. but that money was split between the state and localities. So I believe it was localities, municipalities that had more than 200,000 people were offered an individual allocation. And so the way that the money went out was the state had an allocation of around 880 million, and the localities received allocations as well. What the state realized was that it was going to be really difficult to administer this program with 1 million different municipal governments having their own programs, in terms of being able to code for that in the platform that we were going to use for people to apply for the state's program. So we tried to entice localities to put their individual allocations into the state allocation, and really take advantage of the state platform. So they weren't going to have to put together the IT solutions to run their own programs. They weren't going to have to do the eligibility determinations themselves. And we also assured them via MOU that residents in their area would be guaranteed the same amount or more if as the allocation that was given to the municipality. So the municipality wouldn't be losing out on any amount of money for their residents by joining the state program. In fact, they would be open to a larger pool of dollars that would be available for applicants. Yet and still, several municipalities did decide to start their own programs, and those are Monroe County, the city of Rochester, Onondaga County, the city of Yonkers, Hempstead, Islip, and Oyster Bay. So applicants from those municipalities and areas cannot apply for the state's program, although that was changed in the September tweaks that the legislature did to the rental assistance program. So the new changes say that to the extent that funds are available, that funds first are expended at the local level. So the municipality no longer has money to give to applicants in their area, then the applicants would then be eligible for the state program. But originally they were not eligible. So up to 10% of the monies were eligible for administration. That is actually only for ERA 1. For ERA 2, the feds opened it up to 15%. Really trying to work with the community-based organizations to get the word out, to also assist people in filling out their applications, although there was a very large and is a very large call center that assists people in filling out the applications and answering questions. So New York State received their first allocation of ERA 1 in winter of 2021, and we began negotiations with the state legislature to form the requirements of the program. There were other states that leapfrogged their legislatures in putting together their program because there really was no requirement that it was part of, a enacted budget, or it was a direct allocation to the state, and the state could, if it chose, unilaterally administer the program. However, the executive did see wisdom in working with the legislature and advocacy groups to really have a collaborative approach to the requirements and specifics of the program. And it was really interesting to negotiate it down to a final document. The Assembly had a very different vision than the Senate did, and some of the hurdles that we had to overcome were, which is federally allowable, was to be paying tenants directly. We and in the end landed on paying landlords or doing a reserved payment that I'll talk about a little bit later. But some of the challenges, although it is federally allowable, in paying tenants. There is a follow-up mechanism that would have had to be created to make sure that tenants were actually paying landlords. The situation of a tenant saying they did pay the landlord and the landlord saying they did not pay the landlord. This funding counts as income when it goes to the landlord, so they have to submit an I-9 on in conjunction with getting paid. And so dispersing this money to tenants would be very tricky in terms of, is it income to them that they are now paying out on their own behalf? Would that kick them off of public benefits that they are otherwise eligible for? So we try to circumvent all of the pitfalls that paying the tenant directly presented by either in the first instance paying the landlord directly, or in the second instance reserving a payment for a tenant whose landlord was either not coming forward or not being cooperative for a period of 180 days. So in the end, we codified ERAP under Chapter 56 of the laws of 2021, subpart BB, as part of the executive budget. So some of the provisions in terms of eligibility, the household gross income has to be at or below 80% of AMI. And just for a small reference on what that looks like, in Albany County, a family for 80% AMI is $76,500 for a family of 4. So the hardship in terms of association with COVID-19, either directly or indirectly, had to be on or after March 13th. So if a household member received unemployment benefits or experienced a reduction in income or incurred significant costs because directly or indirectly associated with the pandemic, the applicant has to have rental arrears that were accrued on or after March 13th, and the household must be at risk of experiencing homelessness or housing instability. Now, one thing about that last provision that was part of the statute, but in terms of interpretation, rental arrears owed are sort of a prima facie case that you are experiencing or at risk of experiencing homelessness or housing instability. It's not a separate prong that has to be proven. There's no requirement that a landlord has initiated eviction proceedings against you. So eligible expenditures. So the amount of payment would be covering up to 12 months of arrears and 3 months prospective rent for significantly rent burdened households. So the definition of that is when the household's gross income is 30% or more of their rental obligation. So they would be eligible for 3 months prospective rent. Utilities, what we tried to do here is do a cross eligibility determination for HEAP so that we could maximize federal funds. We didn't want to use ERAP dollars for individuals who are HEAP eligible. So we tried to get HEAP to cover as much of utility arrears as possible. And then there's also a provision that allows for utility companies to get a tax credit dollar for dollar for forgiving utility arrears of a applicant. And then if in the last instance, if we couldn't figure out any other way to get those utilities paid for, we use the ERAP funds. You do not have to be the primary renter. Subletting, both formal and informal arrangements are eligible for ERAP. So other flexibility that is a part of ERAP, there is no citizenship or immigration status restriction, no requirement that your landlord file for eviction, and no limit on how much money owed during the covered period. So we thought that if there's some reverse engineering in there, because it's unlikely that someone would have less than 80% AMI, but be in housing that was significantly above FMR. So we didn't put in limitations on rental amounts owed. So I think the real meat and potatoes of ERAP are the tenant protections that it provides for people who are eligible and whose landlords are either getting paid by ERAP funds or could be paid if they came forward with all of the needed information to in fact have the agency issue the payment. So once an individual applies, they're protected from eviction based on non-payment of rent during the same period for which they have applied for relief. And I think we've already said this a few times before, the proceedings are stayed. So it's not, a complete protection from eviction, but the proceedings are stayed until the determination of eligibility or ineligibility. So if a tenant is deemed ineligible, that protection ceases, although there are other programs that we've talked about, other statutes, specifically the Tenant Safe Harbor Act and the eviction moratorium that could be at play for an individual who just happens to be ineligible for the ERAP program. So if a tenant is deemed eligible, both the landlord and the tenant are notified, and the state will attempt to get all of the necessary information from the landlord to make the payment. Because remember, the tenant has already given all their information to assess eligibility. So really, it's now up to the landlord, if they haven't already done so, to get all of their information into the state. And if the landlord does not provide the requisite information, the state will notify them that the payment will be reserved for 180 days, after which time the landlord may not be able to access the money. And so my understanding is that these notices are just now going out. If not, they're coming out imminently from OTDA. And the language that I've seen pegs that 180 days from the date of the notice and not the day of the determination of eligibility. So more tenant protections. Once the tenant is deemed eligible, regardless of whether the landlord accepts the payment or not, the landlord is prohibited from seeking a money judgment or possessory eviction based on the non-payment of rent during the time covered by the reserved payment. This is pretty straightforward. A landlord can't say, I want to evict you for not paying rent, even though you have been found eligible for state assistance that would pay me for that same rent during the same period. If we're talking about rent owed outside of the covered period, or proceedings that are associated with actions outside of the covered period, that is not subject to the ERAP protections. I think it's important to note that ERAP is a lawful source of income. It's covered under human rights law, and it is possible for a tenant to bring a discrimination claim with DHR against a landlord that affirmatively refuses payment based on the source of the payment being ERAP. Whether or not they are not happy with the tenant protections, specifically the next bullet of when the landlord has accepted payment, they thereby agree not to raise the rent for 1 year and not to evict for 1 year without good cause, including holdover tenants. So, there may be a landlord that says to their tenant, I know what happens when I accept this payment. I'm not going to be able to raise the rent, and I'm not going to be able to evict when I feel like it. So I'm not taking that money. That is a violation. So, ERAP is a lawful source of income, and they cannot discriminate against it. So one note on the raising of the rent, the rent controlled, so the rent control board that decides what the increase on rent controlled apartments is going to be year to year does not count as an increase in rent under the ERAP program. Next slide. Okay, so these are the changes that the legislature came back to tweak the ERAP program in conjunction with extending the eviction moratorium and trying to solve for all of the problems that the Supreme Court pointed out in terms of those hardship declarations and the process generally. So the first piece of the changes as concerns to ERAP is that those applicants that were in municipalities that had their own programs were not previously eligible for all of the robust tenant protections that we put in the state program. So there was a real concern that it wasn't the applicant's fault. I live in Islip or Islip, however they say it down there. I don't have any control over the fact that my municipality decided to have their own program and didn't fold into the state's program and therefore provide me with these great protections. So the legislature extended all of the protections of the state's program to those applicants in the municipalities that have their own program. Now, I have not heard yet of challenges to that because I can see a circumstance where a landlord took payment under a local rental assistance program with no restrictions on whether or not they could raise the rent. And so in terms of contractual obligations based on those local programs, I think that there could be challenges if they try to retroactively enforce those provisions, but we'll see how that shakes out in the courts. Hold on, go back. Okay. So it also clarified that the expired lease or holdover tenants could be evicted for cause. We thought this was inherent by only stating, the reasons that were protected in terms of money judgments and eviction proceedings based on non-payment for the monies in the covered period. But the legislature wanted to make it absolutely explicit that you could evict for actions that substantially infringe on the use and enjoyment of other tenants or cause significant damage to property. So that was spelled out in the tweaks to make clear that a for cause eviction would be permissible. So here are some of the other programs that are available. So there's a state ERAP program that's distinguishable from the federal one that I just talked to you about. The state ERAP program is for individuals that are between 80 and 120% of AMI that are otherwise eligible for ERAP. And that, just for a reference, is about 114,720 gross income for a family of four in Albany County. So, we're pushing more into the middle class there for a family of four. And the additional information about that program can be found on OTDA's website. There's a few hundred million that they have allocated for that program, and they are taking applications. It's first come, first serve at this point. I think there were some priorities in the beginning, but now it's first come, first serve. So please check that out if applicable. And then there's a program for landlords. It's a landlord hardship program for individuals that are property owners and their tenants owed money and are either willfully refusing to participate, to apply for ERAP, or have vacated. And you have no idea where they are, and you're sort of left holding the bag as the landlord for many months of owed rent. We already talked about the eviction moratorium that was extended till January 15th of 2022. And there is a homeowners assistance program for individuals that have fallen behind on their mortgage due to loss of income or unemployment caused directly or indirectly by the pandemic. Although it is not yet open for applications, I believe the plan that's required by the feds to administer it has been submitted by HCR, Homes and Community Renewal, but has not yet been approved. So I would just keep your eye on HCR's website to keep an eye on when that program will be up and running for eligible applicants. So essentially the amounts allocated to the state for the federal ERAP, OTDA is announcing on their website, are starting to dwindle. They're still taking applications, but they're not sure if they'll have enough money to continue making payments to the people that apply now. This is a moving target because remember, you have a group of people who have just been paid, landlords that have just gotten all their information in and been able to be paid. There are 180-day notices that are going out and payments are being reserved. After 180 days, that money could go back into the general pot. However, there are provisions that allow a landlord to come forward within 12 months for those monies. And it's unclear at this point whether the state is going to honor that past the 180-day period and before the 12-month period. After the 12-month period, the unpaid monies during the covered period for which the applicant has been approved are deemed released. So there will be no relief for landlords after 1 year for monies that OTDA was ready and willing to pay, but the landlord did not come forward. So, it's unclear at this point how the money is going to flow in and out of those 180-day reserved payments. And the counties listed where they're saying, we don't know if we'll have enough money, but the people in Dutchess County, Erie County, Nassau County, except for Hempstead and Oyster Bay, et cetera, should apply, is because what I told you all in the beginning, where we were trying to entice municipalities to join the state program. And we said, we solemnly swear to disperse at least the amount of money to your residents that you received in your allocation from the feds. So those counties are the counties in which the OTDA has not received enough applicants with enough rental arrears owed to pay out or reserve the amount of money that that county got in a direct allocation from the feds. So that's what that is about. And so those are the resources where you can find all things ERAP on OTDA's website, and then the HCR website for the homeowners assistance program. So thank you so much.
Thank you so much, Jillian. And she did include several, I think, really good resources, which you all should have gotten in your materials today as well. Let me know if you did not. I do have some follow-up questions for you, and I do want to go back to that one that was asked originally during Jasmine's presentation. The question is, I am a staff attorney for a Chapter 13 trustee. I am wondering if you see or hear of bankrupt debtors or landlords taking advantage of the ERAP or landlord protection programs. We are seeing cases dismissed for lack of payment, and it is unclear whether the debtor tenants or debtor landlords are taking advantage of the programs. Can you please discuss?
So I am not a landlord tenant expert. However, I'm pretty sure of a common law requirement to cure, right? That a landlord who has the ability to, get money to acquire payment for rent has the common law duty to do so. I mean, I'll kick it over to some of the more experienced landlord tenant attorneys, but my baseline response would be a landlord can't sort of shirk the requirement if it's available to them to get the money through ERAP.
Any other thoughts or?
We haven't seen any situations like this as far as bankruptcy debtors, at least not as far as I know.
Okay, thank you. Another one is there a priority based on the circumstance of the applicant? What is the estimated timeline for approval?
So there were priorities in the first 30 days of the program. Those priorities are no longer active or applicable. It's really first come, first serve. But some of the previous priorities were survivors of domestic violence, coming from a zip code disproportionately impacted by COVID, veterans, and those who are or were unemployed, but not currently in effect. And this is just a rudimentary, I do not work at OTDA, so, but my memory is that start to finish is about 2 months application to payment.
All right, another one is, can a landlord evict for non-payment of rent after the ERAP period?
Yes,
Sounds simple.
it's the covered period. That's the magic word, the
All right.
covered period.
Is funding still available for the LRAP program, noting that ERAP is all spoken for in many counties?
So I think that's the landlord assistance program. I am not aware that that program has closed. OTDA has not posted on their website that the landlord assistance program is closed. So I would assume that it is still open and accepting applications.
I would say it just started October 7th, so I think it would be pretty unlikely it's closed already.
All right, and we are eating into our next presenter's time. So I'm gonna ask one more question here. Is the tenant required to be noticed if the landlord files for LRAP? Is the landlord precluded from the LRAP grant if the tenant is withholding rent for habitability issues?
So this is not ERAP, that's LRAP. And I'm not familiar with the provisions of LRAP, I'm sorry.
Oh, that's fine. All right, and it does look like someone did comment in on the bankruptcy question that was earlier, so I'm just going to kind of relay that message. It says 11 USC 525 prevents denial of access to a rent grant program due to a bankruptcy filing. So, all right, and with that, thank you so much, Jillian, and we will go on to our next presentation. Actually, first we will do our next CLE code word, which is pro bono. So the first one, if you missed it, was celebrate. The second one is pro bono. I'll leave that up on the screen for a little bit while I present our next panelist, who is Ms. Vera Johnson. Vera Johnson is currently licensed to practice law in New York State courts and before the United States Supreme Court. She is a former litigation attorney with the New York State Department of Taxation and Finance from 1989 to 1998, and an administrative law judge and supervising administrative law judge, respectively, with the New York State Office of Temporary and Disability Assistance Administrative Hearings. That was from 1998 to 2018. Having retired from state service on October 31st, 2018, Vera graduated from Albany Law School in May 1989 with a Juris Doctorate degree, and in May 2008 from Christ the King Seminary with a Master of Arts in Pastoral Ministry. Vera Johnson is an ordained minister and currently handles cases on a pro bono basis for Legal Aid Society, including many cases through our Attorney for the Day program, which is what she is about to speak on. She also handles cases with Rural Law Center and Legal Assistance of Western New York. Bonnie. Thank you.
Thank you so much, Mallory. Good afternoon. So the object of my presentation is to give you a practical view of the Attorney for the Day program. The Attorney for the Day program is essentially based on limited scope representation of low-income tenants. It currently operates in Albany, Troy, and Glens Falls, and it's similar to pro bono program models that are operating nationally in Boston, San Francisco, New York City, Buffalo, New York, etc. It's unique in that it's limited to the client's initial appearance. You don't have time to do any in-depth research, conduct a thorough investigation of the facts and circumstances surrounding the issue. However, it does provide you with an opportunity to sharpen your negotiation skills and your courtroom skills. A typical day consists of client interviews, negotiations, and the initial appearance before the court. It's always a good idea to arrive early. Troy City Court begins at 8:30 a.m. and Albany City Court begins at 9 a.m. A copy of the docket will be distributed to you on the morning of the court calendar, for which you volunteered by Rylan Wiseman. He is the private attorney involvement paralegal. Both legal aid and the attorney for the day will review the court calendar for conflicts, make sure those conflicts are stricken before the AFT rotation begins. The docket can be accessed online if you prefer not to wait, and the website is provided for you on the screen. Client interviews. As people enter the waiting area, Rylan will greet them and ask them if they would like legal representation. For virtual hearings, when the case is called, the judge will note that legal aid is present and then will ask if the respondent is interested in legal representation. If the respondent responds in the affirmative, then a breakout room is provided so that we can firstly conduct the eligibility assessment, and then if the client is eligible, proceed to discuss their legal circumstances. If it's not a virtual hearing and the respondent has appeared in person, then usually we have a room off of the main courtroom to discuss the client's legal circumstances. At the outset of the interview, I always like to stress the limited scope nature of the representation. In the first instance, I always like to obtain any relevant correspondence received by the client. If the client does not have the notice of petition or the petition, I usually, with the assistance of Rylan, will obtain it from the court. Only as a last resort will I look to opposing counsel for the notice of petition and petition. I find that the court copies are complete. They have all of the attachments, the predicate notices, the proofs of service, the hardship declaration forms, etc. At the outset, we are trying to gather as much information as we can in a short period of time as it relates to those various substantive areas that we've gone over, in particular jurisdiction, proper and necessary parties, affirmative defenses, and counterclaims. Negotiation is one of the crucial elements of what we do through the Attorney for the Day program. Our goal in this program is to wrap up the case on the day of the initial appearance. And so we find that we are leveraging and attempting to negotiate according to whatever the client's wishes are, but we'll use such things as a good history between the landlord and the tenant. And generally speaking, landlords try as hard as they can to retain good tenants. There will be times that we will settle, even though the client appears to have a strong case. And that is in connection with the uncertainty of litigation. So when you appear at the Attorney for the Day program, you'll be confronted with a lot of different situations, and each case is different, and the outcome will depend on a variety of factors. Most tenants have heard about the eviction moratorium, but not the nuances. So they'll come in with a signed hardship form, but yet it will be a situation in which they are being evicted based upon a lease violation because they have persistently and unreasonably engaged in behavior that substantially infringes on the use and enjoyment of other tenants. I have also found that in the Attorney for the Day program, it's also good to be aware of available resources in your area that will assist in bringing about a resolution. Landlords often will wait for a DSS application to be processed. United Tenants also has funds available, Catholic Charities, as was mentioned previously. And we would like to notify you that landlords will give tenants an opportunity to apply and often will concur with a request for an adjournment on that basis. So on the record, at the initial appearance, you'll discover that different judges have different methods of how they handle and conduct their hearing. So it's a good idea to observe a few of the cases at the assigned location before you make your first appearance on behalf of a client. The judge will routinely say something like, "We're on the record in the matter of Dog v. Pony, LT 00119334. This is an initial appearance, da 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 da." When noting the appearances and presenting the case, the attorney for the landlord usually goes first. Be sure to provide the respondent's response to all aspects of the petitioner's statements. Some judges will gently push the parties towards a resolution. If you reach an agreement, most judges will go over the terms and obligations of the stipulation and ask the client to confirm on the record his or her understanding. Next slide. So at this point, I'd just like to go over a few scenarios that you may encounter. Rylan tells me that you would like legal representation on a housing matter. My representation is through the Legal Aid Society of Northeastern New York and is limited to the first appearance before the court. I can't provide legal assistance through the Attorney for the Day program after today's appearance, but I may be able to help you resolve this matter today. What's your landlord claiming? Do you have any papers or documents that he gave you about this situation? The client responds, "I didn't receive anything, just the papers that told me to be here today." So the Attorney for the Day responds, "So then let me see those papers." The client says, "I didn't bring them with me. I couldn't find them." And then he goes on to say, "But anyway, I told the landlord that there were some problems that I needed fixed from the day that I moved in." And he's about to tell you the whole history of his tenancy and his relationship with the landlord, for which you don't have time. So what would you do? In this case, I would get a copy of the petition and attachments from the court or the opposing counsel. Review each and every allegation contained in the petition and the predicate notices with the tenant so that I could understand their view of the issues that are being raised. Review the affidavits of service and the certified mail receipts, analyze possible defenses, find out what outcome the tenant is looking for, and advise the tenant how close I believe they can come to reaching that goal. Next slide. Scenario number 2. The tenant says, I really need your help. I'm being evicted for not paying rent. The attorney for the day, looking over the papers that have been provided to him, says, what's going on? The tenant said, I fell behind in my rent. The attorney for the day responds, how much is your rent? The tenant responds, $850 a month. The attorney for the day responds, how far behind are you? The tenant says 2 months. The attorney for the day then says, the petition says 3 months. The tenant says, I paid $1,275 2 weeks ago. Then the attorney for the day says, well, when can you pay the balance of the rent owed? Do you have money today? Moving on to the next slide. Tenant says, I have $500 here today. I can come up with the balance of $775 in 60 days. The attorney for the day then wants to know, what about the current rent as it becomes due? Will you be able to keep up with the current rent as well? And the tenant responds, it's going to be difficult. I'm starting a new job delivering for DoorDash next week, and I should be able to. And the attorney for the day then asks, why did you fall behind? The tenant says, I fell behind because my roommate left 3 months ago. I paid my share, but the landlord is looking for the share of the roommate. The attorney for the day says, is the roommate on your lease? And the tenant responds, no, there is no lease. I rented the place and let my friend move in last year when his partner left him. What would you do? In this scenario, I would suggest that you complete and have the tenant sign and file the hardship form. The reason why I would suggest the filing of the hardship form is because this tenant has suffered a significant loss of household income that he was getting from the roommate during the COVID-19 pandemic. I then also would ask the opposing counsel to agree that the matter should be stayed until January 15th of 2022. And this will give the respondent ample time to pay the balance. I had a case very similar to this one where the opposing counsel was of the opinion that the income that the tenant was receiving from the roommate did not constitute household income.
Can I just mention something real quick, Vera?
Yes, please do.
Okay, I just want to draw a distinction on that point. Whereas Jilliane correctly stated that the ERAP eligibility, the loss of income or inability to pay the rent has to be directly or indirectly related to COVID. It's not true with the hardship. It just has to be during the COVID period. I say that and stress it because there are a couple of judges in the Capital District that think that the hardship for the hardship declaration has to have been caused by COVID. It's an interesting theory, but not what the law says. It has to be during the covered period. So I just wanted to draw that distinction. Pardon the interruption.
Thank you, Bob. And that is exactly what the scenario was attempting to do, make that distinction that it was a significant loss of income during COVID. Moving on to scenario 3. The lawyer says, hi, my name is Vera Johnson, and Rylan Weissman with the Legal Aid Society of Northeastern New York passed along your housing court case to me. He said, you want some legal assistance today. The tenant responds, "That's right. The landlord said that I need to get out right away because I violated the lease." And the lawyer says to the tenant, "Did you bring any correspondence or papers that you received in connection with this court matter?" And the tenant said, "Yes. Oh, by the way, I signed this form. I don't want to stay. I need about 90 days to get out." The lawyer responds saying, "This is a declaration of hardship form. While we are waiting, let's talk about what's going on." Next slide. In reviewing the petition and predicate notice, the attorney discovers that the petition says on several occasions the tenant has been caught on camera breaking into vehicles, ranting at staff and other residents, and physically fighting with residents. He has been arrested on at least one occasion in connection with the bad behavior. The first notice of termination indicates that the premises must be vacated within 10 days. The second notice of termination is issued adding a few more incidents of bad behavior. And then a third notice of termination is issued also adding a few more instances of bad behavior. You have looked up the circumstances, and you find that on page 68 of the bench guide to landlord and tenant disputes in New York, you find that a notice of termination should, among any other things, when based on the breach of a lease, identify the breach provisions. So recognizing that this particular section is talking about stabilized rent, you indicate to the tenant that we may be able to argue this, but it's not really going to carry the day. And so therefore, we're going to just see if we can get the landlord to give you the 90 days. So the landlord responds, "The staff is afraid of the tenant. Criminal charges are pending against the tenant and we want him out as soon as possible. 30 days is it." So you mentioned to the landlord that the notice to terminate lacks specificity and that the landlord can actually save money by the client staying at least 90 days. The landlord is not convinced. What do you do? Well, you explain to the tenant that the hardship declaration form that he signed does not provide protection when the cause of the landlord's case is based on behavior that is persistent and unreasonable and infringes upon the right and safety of the other tenants. You also tell the tenant, although you could make an argument that the notices of termination are defective, that the case law surrounding that proposition applies to rent stabilized unit, and there's no guarantees when it comes to litigation. So eventually, this particular case results in an agreement between the parties to give the tenant 60 days. One caveat you give to a tenant in this situation who may not be able to get out in 60 days is that he can always go back to the court and ask the court for a stay of the warrant, showing that he was unable to find housing. And if he's unable to locate housing, he will be granted an additional period of time within which to file or within which to move, possibly up to 1 year. Highly unlikely, but it is possible he can get at least another 30 days. The fourth and last scenario is a scenario in which the client received a 5-day notice for each of the months at issue, September, October, and November. Attached to each notice was a hardship declaration form. On November 20th of 2020, a process server served the client with a 14-day notice, and the client was instructed in that notice to either pay the rent arrears or to vacate the premises. Attached to the 14-day letter was a declaration of hardship. The client was then served with a notice of petition and verified petition, and attached were the proofs of service in connection with and certified mail receipt in connection with the 5-day letter and the 14-day notice. So client appears in court on the day that she's told to come in, and client is adamant that she has experienced no financial hardship during the COVID pandemic, and she's not amenable to moving. She's indicated that she wants to stay where she's at. Next slide, please. She explains to you that 80% of her rent is paid by DSS. She alleges that DSS and she have withheld the rent due to the landlord's breach of warranty of habitability. Next slide, please. So what would you do? In this particular case, because it's not just the tenant who is withholding rent, she's also holding rent under, or DSS is withholding rent under the Spiegel Act because there were code violations that were hazardous, dangerous, and unsafe to the tenants. So as a result, her case really became much stronger. In this particular case, she had the income set aside in an escrow, and as a result, her share of the income, and as a result, she was ready, willing, and able to pay. Negotiating with the landlord initially was problematic because he was arguing that he did not receive notice of any unsafe or dangerous conditions. However, his argument was without merit because when DSS terminates the shelter payment, they provide notice to the landlord as to why the shelter payment is being terminated. So therefore, he was put on notice and he wasn't getting anywhere with that particular argument. It turns out that this matter was successfully settled within 30 days before this case came back up on the court calendar. This client was satisfied that all the repairs had been made and DSS had started the process of releasing the funds that had been withheld to him. I also want to point out as a final note that under the Spiegel Act, DSS is only allowed to withhold rent if the code violation is hazardous, dangerous, or unsafe. In situations where it is a minor code violation, something like a banister being loose, that is insufficient to trigger the Spiegel law. Thank you very much. Are there any questions?
Thank you so much, Vera. We do have a question, just came in. Can a landlord bring a nuisance challenge to the hardship declaration without there being an underlying predicate notice for termination due to the nuisance?
I'm sorry, could you repeat the question?
Yes, sure. Can a landlord bring a nuisance challenge to the hardship declaration without there being an underlying predicate notice for termination due to nuisance?
No. No, there must be a predicate notice for the nuisance behavior. The hardship challenge, there's a specific exception under the COVID regulations for the moratorium eviction, and the hardship declaration does not pertain to nuisance behavior.
Thank you, Bob. I saw you unmuting and remuting yourself. Did you have something you wanted to add to that?
I guess I was only going to say the only exception, I think, to what Vera said would be if the lease required that, I mean, say that the behavior that they're claiming as a nuisance, the lease says that you have to give a notice to cure or something like that, then I think you'd have an argument that there'd have to be the notice. But this is kind of the question that was asked before. What's the predicate notice required for nuisance? Depends on what the lease says. If their lease doesn't have a requirement, I don't think there is one.
All right, well, thank you so much. And I will just say, just kind of put in a little plug here. If any of you are attending today with the intention of covering a few attorney for the day cases, one thing I would encourage I would encourage reaching out to myself or Rylan Weissman, who is our paralegal, and we would be happy to have you come and observe before you actually take on any cases and run the program yourself for the day. A typical day can last anywhere between 2 to 3 hours in the morning. But in the event that we see that the docket ends up being slower than we thought, we can end up wrapping up earlier than we thought. In the event the docket is, more than we thought, we can end up being there a little bit longer than we anticipated. So it can vary on time. But if that is what, if you signed up today with that interest in mind in working through that program or volunteering through that program, but you're not really sure and you kind of want to test the waters before you jump right into it, I would strongly encourage you to just come and actually observe the process in play itself. So with that, I will move on to our next panelist, who is yet again, Mr. Romaker. He is going to be speaking on the ethics of some of the limited scope representation rules that are in play here with these kinds of programs. So Bob, back to you, please.
Okay, hello everybody again. I hope we're firmly entrenched in the post-lunch period. I hope everybody's awake and alert and for this exhilarating ethics presentation that I'm about to give here.
Everybody loves a good ethics CLE, Bob.
True. I'll try to make it as interesting as I can. Okay, so what we're talking about, obviously, in this context is limited scope pro bono services. Vera referred to some of this in her presentation. It's also known as unbundling legal services. This is only one context that this applies to. It can be advice only clinic, or I won't represent you in your dispute with your neighbor, but I'll send the neighbor a letter, kind of thing like that. It's an alternative to kind of an all or nothing model where either I will represent you all the way through the resolution of your legal problem, or I won't. This is kind of a happy medium to do specific tasks like a court appearance, an attorney for the day, or I'll give you some advice or something like that. Something short of fully representing someone all the way to the final resolution of their problem. Obviously, the hope here in these limited situations, and I think like Vera said, is that, in the attorney for the day context, the goal is to try to resolve everything right there. The attorney for the day is a one-shot deal unless they decide on their own to extend it further. And so the idea is to make it so that if you can reach a resolution, that the tenant doesn't have to come back to court again. So it's the same standard of care with a full service model, even though you're doing a limited service, and it's beneficial for clients, courts, and legal services organizations. The professional conduct rule 1.2 talks about this, that a lawyer may limit the scope of representation as long as it's reasonable under the circumstances and the client gives informed consent. Again, limited scope representation is allowed, informed consent is required. It says notice to opposing party and or court when necessary. One of the things I wanted to mention is that I don't know, as an attorney for the day, if I would highlight to the landlord or the landlord's attorney that this is a one-shot deal, because it might, and maybe this is my cynical mind going to work here, but it might induce the landlord or their lawyer, not all of them, maybe some of them, to not reach an agreement at that time, knowing that the tenant would have to come back at a later time and do a trial on their own, at which they would be at a disadvantage unless they found other representation, because the landlord would be represented at that subsequent appearance and the tenant would not. Okay, this is a comment to the rule 1.2C. In obtaining consent from the client, the lawyer must adequately disclose the limitations on the scope of the engagement and the matters that will be excluded. In addition, the lawyer must disclose the reasonably foreseeable consequences of the limitation. In making such disclosure, the lawyer should explain if the lawyer or the client determines during the representation that additional services outside the limited scope specified in the engagement are necessary or advisable to represent the client adequately. The client may need to retain separate counsel, which could result in delay, additional expense, and complications. So basically, it's incumbent in this context for the attorney for the day to explain that if the matter is not resolved today because it's adjourned or it's set for trial, then you are not going to, I'm not going to be there for you. Again, this is a less in the limited circumstance that the attorney for the day takes it upon themselves to say, okay, I'll see this case all the way through for whatever reason. That's not usually the case. That would certainly be the exception, not the rule. But so you would have to disclose that to the client and say, listen, I'm here for today. If it's set for trial later or adjourned until later, you're going to be on your own. You're going to have to find some other counsel. There are circumstances in that situation where the tenant could call our office and we could consider it as an in-house case. That would be one of the options. They could be referred to the State Bar Association that has a lawyer referral service. Or, you know, if they just need money, they could be referred to United Tenants. They could be referred to DSS, Catholic Charities, ERAP. So it really kind of just depends on the circumstances of the case. But the reasonably foreseeable consequence of the limitation have to be disclosed, and you have to discuss this with the client in order for there to be the informed consent that's required. The tenant, in making their decision about, do I want to settle, or do I want you to argue for dismissal, or do I not want to settle, do I want to go on a trial, they need to understand that you're here to help me today with the negotiations and maybe argue a dismissal. But a reasonably foreseeable consequence would be if I don't, you know, if I want 60 days and the landlord's offering 45 and I don't agree to that, I may end up coming back and having a trial in which I lose and I get a warrant served on me and I get 14 days. So maybe I really should take the 45 days, that kind of thing. And an explanation about what to do if further assistance is required, like I mentioned, and Vera mentioned, it's important for the lawyer, that's the attorney for the day, to understand what the options are and what other services might be available. And if you're new at this and it's your first time, you don't know, the private attorney involvement person, Ryland, who would be there for our office, would know what those resources are. Okay, so the professional conduct rule 6.5 talks about this a little more expansively. It specifically talks about conflicts of interest. A pro bono with the government or court-sponsored programs, bar associations, legal nonprofits like Legal Aid Society of Northeastern New York that offer short-term limited legal services to a client. Compliance with the conflict of interest rules are necessary only if the lawyer has actual knowledge at the time of the commencement of representation that the representation of the client involves a conflict, and the lawyer has to comply with the rule 1.0 10 about imputation of conflict to other firm members only if they have actual knowledge. So if for example, the tenant comes to you, you say, who's your landlord? And they say, it's, Tom Smith. And you know that your firm represents Tom Smith in all kinds of contexts, and you have actual knowledge of that. You have to back off and say, I can't assist you. Perhaps Ryland could assign another attorney for the day lawyer that's there, if there's more than one there, which I think there usually is. But that's actual knowledge. So you don't have to, I think that this rule recognizes the practicalities of the situation, like the attorney for the day program. Things are moving fast. We have to make eligibility determinations. You have to gather the paperwork. You have to make a snap assessment of the case. You have to try and negotiate it. And sometimes you've got the judge there calling your case saying, come on, let's go. So you don't have time to go look at your firm's database to see if you have a conflict, or to call somebody at your office and say, hey, can you check conflict on Tom Smith? So the reality is, and this rule actually sanctions this, if you can move forward, even if there was a conflict, as long as you don't have actual knowledge of it. So that's what the rule is there. The short-term limited legal services are services providing legal advice or representation free of charge as part of a program described in paragraph A with no expectation for continuing representation. So this only applies in these scenarios. It doesn't, obviously the conflict rules don't change if you've got somebody who comes to your office and you're a private lawyer or whatever, and it's outside of the context of a pro bono program. Informed consent is required, as we talked about a minute ago, and the representation, like any representation, is subject to the provisions of Rule 1.6 relating to confidentiality. The exception is if their conflict of interest, if the matter is pending, the court determines that a conflict of interest exists, or if during the course of representation, the lawyer providing the services becomes aware of the existence of a conflict of interest precluding continued representation. And I guess that could happen. I guess in the example that I said, it's say Tom Smith is the landlord, and they start negotiating, and he says, I know that lawyer. I go to that law firm all the time for my representation, and I see, I don't talk to that person, but I know that I'm represented by that firm, and I see this lawyer all the time, Judge. I don't think this is fair. I think this is a conflict of interest. Then at that point, you're in a different ballgame, and I think the court can determine, which is very strange. Courts don't usually get involved in the interpretation of ethical rules. That usually is involved with local bar associations and state disciplinary boards and things like that. But in this instance, if it's raised that there's a conflict and it's determined that there is one, even if the lawyer didn't have actual knowledge of it, then it becomes an exception to allowing representation to proceed in this context. More about informed consent. It's defined in the rule as the agreement by a person to a proposed course of conduct after the lawyer has communicated information adequate for the person to make an informed decision, and after the lawyer has adequately explained to the person the material risks of the proposed course of conduct and reasonably available alternatives. A lot of this is common sense, which I know isn't that common anymore in some contexts, but obviously in order for the tenant to be able to make a decision, it has to be an informed one. They have to know what the risks are. They have to know what the benefits are. They have to know, if you don't take this agreement, this is what could happen. If you do take this agreement, this is what could happen. The merits of saying, well, maybe you don't want to take 45 days. Maybe you should push for 60 days because I've identified 3 defenses that I'm going to interpose to get this case dismissed, and I'm going to try to use that to get you the extra 15 days. Basically, the context of the risks, the benefits of going either direction, that's informed consent. Here, this is, I believe, the limited appearance retainer agreement that we have the client sign. That I'm not really even familiar with this form that much, but I'm assuming that it talks about the limited scope and the limited nature of the representation at the attorney for the day, that it doesn't cost you anything. And here's how here's how this works, and that this is not your lawyer in perpetuity, but it's your lawyer for today. You have any questions? Sign here, please. Again, with informed consent, you can limit the scope of representation as long as it's reasonable. You get the informed consent, and where necessary, notice is provided to the tribunal and or opposing counsel. The rules of duty of care, competence, diligence, all the rules that would apply to any other representation or assistance that you would provide a client, all the professional rules that are listed here apply. Again, noting that there is an exception for the conflict of interest rules, as stated a few minutes ago. Okay, so a little bit more about the conflict of interest. A lawyer who, under the auspices of the program, provides this short-term limited legal services, he has to comply with the conflict of interest rules only if the lawyer has actual knowledge at the time of the commencement of the representation that there's a conflict. If you don't know, then you're fine. And you have to comply with Rule 1.10, which I believe is the imputation of a conflict of interest to other lawyers in the firm. Again, only if you have actual knowledge at the time that you start that another lawyer in your firm or associated with your firm has a conflict. While representing a client in connection with the contemplated or pending litigation, a lawyer shall not advance or guarantee financial assistance to the client. You're not allowed to give money to your client or help your client or say, hey, you owe $20 in rent, here's $20, except in this context, when you're representing an indigent or pro bono client, you can pay court costs and expenses of litigation if that's an issue. A lawyer providing legal services in this context without a fee for a legal aid or other public interest organization or a law school or clinical or pro bono program can provide financial assistance, but cannot promise or assure financial assistance prior to retention or as an inducement to continue the lawyer-client relationship. In other words, you can't say, I'll pay the court costs for you as long as you come see me next week to talk about that personal injury claim where you were severely injured, for example. Funds raised for any legal services or public interest organization for purposes of providing legal services will not be considered usable for providing financial assistance to indigent clients, and financial assistance referenced in this section may not include loans or any form of support that causes the client to be financially beholden to the provider of the assistance. In other words, if you offer, in order to settle a case, to make the settlement go through to pay court costs and expenses of litigation, you can't get anything out of it, and you can't expect or require or demand that the money be paid back at some later time. Examples that we've, I think, talked about, advice only, hotlines, clinics, help centers, pro se counseling. You know, sometimes in my prior life, when I was a legal aid lawyer in Ohio, we would have clinics where people would show up and lawyers would volunteer their time to just give advice on a one-shot deal. That's the kind of thing they're talking about. Brief services, automatic document assembly programs, attorney for the day, representation in court for that day, completing certain forms. For example, we have a closing the gap program where a lawyer can be in one location and a low-income client can be in another location, and you can go through the program and ask questions, and what ends up happening is it spits out an answer for you in either a housing or a consumer case at the end that the tenant can print out and take to court and file to assert their defenses. That's a brief service. Any of those kind of programs are what we're talking about as far as limited scope representation that these professional rules of conduct apply to. And that's it. Hey, I ran over last time, but not this time. How exciting. Questions, I guess.
We do have a question. I think that the question was actually answered by one of the slides just after this question was asked, but it was, is there an informed consent disclosure form provided by LASNNY for review with and signature by the tenant? I think I'm probably the best one to answer this because I am the director of the private attorney involvement program here. And yes, the answer is we do have that, which is what the sample slide was. And I will say, so before we take on any client through the program, I've actually, because I was hired during COVID, I have actually only gotten to see a handful of attorney for the day programs run because they were all, the courts weren't open and various things. So, but the conversation between Rylan, myself, and/or our volunteer typically goes something like this. We will explain the entirety of the document to them. We will have them sign off on it. We will have them talk to the lawyer, the volunteer, and Rylan will reiterate multiple times, when does your representation end? When does your representation end? When does your representation end? And just to ensure that the client knows that the purpose of the representation is for that day only. I will say it is not completely, well, I guess both as Vera and Bob mentioned, the goal of the program is to get to some kind of agreement between the landlord and the tenant while you're there in court that day. That is not always successful. We do have several volunteers who choose to carry on the case afterwards on their own, which we could continue to do through the PAI department for an extended rep services. That is not required. It is not asked of you, and we would never force that upon you. That is completely 100% up to the volunteer at the time. So I just want to reiterate, it is very much made known to any potential clients that are there that day that the scope of representation ends once that, discussion, negotiation, hearing is over for the day. However, it is totally voluntary choice of the volunteer that day if they choose to continue a representation in the event of an unsuccessful agreement or resolution during that day. So I think I think we have someone else who has missed the second CLE code. So I will just go on and give them again. The first one was celebrate, and the second one was pro bono. But I don't think that we have any more questions than that. I did see some come through chat, but I think that we have addressed all of the questions that have come through chat. So if there are no more questions, then I guess we can go on and start our next break time. So it is 3:37. We will resume back in 15 minutes. I'll make an announcement, and then we will hear Judge Rice give us her views on and perspectives on these kinds of programs from the bench. Thanks, everyone. Back in 15 minutes. Judge Rice, are you by chance on?
I am here. Let me see if I
Wonderful.
can. Okay.
All right. Well, I thought since we ended a little bit early, we could probably go on and get started a little bit earlier, if that is okay with you.
That is fine by me.
All right. Thank you so much. Okay, everyone. So we are back, and I believe actually our next. We have our third and final CLE code word before Judge Rice talks with us. And that code word is weak. Again, if you're just coming back, I apologize. I hope that you can hear me if your screen is minimized. But the CLE code word, the third and final word is weak. And so with that, we will go on and I'll introduce our final panelist, although I have a feeling she needs no introduction, but I will do so anyways. Honorable Ricja Rice was recently appointed to Albany City Court Judge, where she presides over landlord tenant, small claims, commercial claims, code enforcement, traffic, DWI, and other criminal matters. Prior to becoming a judge this past August, she was the court attorney for Albany City Court. She is a graduate of Albany Law School and Union College. Judge Rice is currently the vice president of the Capital District Black and Hispanic Bar Association, whom we very much appreciate co-hosting this full CLE with us, and a past president of the Capital District Women's Bar Association. And so with that, Judge Rice, I will go on and turn it over to you.
Good afternoon, everyone. Thank you to all my co-panelists. This has been a fantastic CLE. The Attorney for the Day program is so important to the court, and so I'm very thankful to the Legal Aid Society for putting on this very valuable service to the court system. So I am charged with giving you the view from the bench. And what I can tell you about the view from the bench is that under the current COVID-19 pandemic, the view is somewhat blurry. I can tell you in terms of what we see from the bench, or a typical day for an attorney for the day from the court's perspective is, you know, when you come into court, especially in Albany City Court, what you can expect from the bench is a review of all the information that my fellow co-panelists have already put forward. And that's a review of the court papers. And really what I focus on is under the pandemic, making sure that the COVID notices have been served, and giving the respondents a chance to review those COVID notices and the hardship declaration to see if any of the stays in place apply. Essentially, as the attorney for the day, when legal aid comes in, and we've notified all the parties that are in court, either virtually or in person, that legal aid is there to assist. The attorney for the day, the main role is, I would say, negotiation. And the court always gives the parties an opportunity to go outside the courtroom in order to try to reach a resolution of the matter, if that's possible, before getting down to all the claims made by the landlord and all the possible defenses that can be made by the tenants. We really try to see if the parties can speak with each other amicably and come up with a resolution that both sides can live with. Once the parties have been able to speak with each other If there can't be a resolution met by the parties, then the court goes into the substance of the claims, any procedural and or other meritorious defenses that may be in place. Basically, under the court's guidance through administrative orders and the statutes that are governing during this period of time, the court makes sure that a hardship declaration has not been served either on the landlord or is in the court file, and to make sure that the tenants are aware of the ERAP program, and to determine whether or not the ERAP program has been applied for and what the status of the ERAP program is. What the ERAP the status of the ERAP application. As a rule of thumb, if there has been an ERAP application applied for, the court has essentially been setting the matter out for 60 days to give the program the time to play itself out. And we essentially ask the parties to contact the court if an eligibility determination is made before the 60-day time period. In terms of what the court is seeing, we're definitely seeing more hardship declaration challenges at this time. And, you know, the case, there's not much case law yet on determining whether or not a hardship challenge invalidates the declaration and therefore would lift the stay. But that is something that the court is seeing more of, hardship declaration challenges, and also allegations of nuisance and health and safety complaints is really what the court is seeing right now in terms of landlord-tenant matters coming before the bench. We do have a couple of default hearings that have gone forward where the tenants have not appeared at all. And so we do see a couple of those. And during the pandemic, unless they have to do with nuisance or health and safety. That's really most of the trials that we see. The attorneys for the day, of course, don't really need to worry about that part of the process, because the attorneys for the day normally appear for the limited focus on for attorney for the day is negotiations and being able to help the parties achieve a settlement that everyone can live with. We've seen some very, very creative settlements, especially in the last month or so, where landlords and tenants have really been able to reach agreements in order for everyone to walk away in a way that does not create a hardship, any further hardship on the landlord, and does not create a hardship on the tenant in terms of either finding alternative housing or getting more time. And essentially, the view from the bench at this point during the pandemic is really assisting the parties, all the parties involved, in reaching a resolution and being able to coexist with each other until we're back to the days where the Tenant Protection Act of 2019, without any caveats or COVID restrictions or stays, are in place. And so things, some hangups that we see on the bench right now are definitely notice requirements. We find that many petitioners were not very aware of all the requirements under the current pandemic. And so the notices were falling short of what was required by the law. What we're seeing on the tenant side of things is really just a need for education on the ways in which the law applies or does not apply in a summary proceeding, the ways that the hardship declaration can protect a tenant or can provide defenses for a tenant. The ERAP application program, we've seen that some tenants may need some assistance with applying for the ERAP program or walking them through the ERAP program. So definitely the attorney for the day, knowing that information, at least the view from the bench is knowing somewhat how that process works and being able to walk the parties through that process is helpful in terms of achieving a settlement for your client. And so outside of the notices and just an awareness of the programs available, I think the view from the bench is a moving target, really. The facts that come before us are often novel or cases of first impression, especially when applying, what's a nuisance in respect to this current pandemic and this law, or what's a threat to health and safety. These are all somewhat novel issues, and we're seeing creative arguments on both sides of what should and should not apply in terms of lifting the stay.
Could I ask you what some of those creative arguments are? Because I have a few that I'm interested in knowing about specifically, so like small claims arguments on the landlord side to circumvent, but I didn't mean to interrupt. I just, if you could elaborate on that a little bit more.
Certainly. And it's good. Questions are good for this topic because the view from the bench always depends on the facts in front of you. And so we do have landlords who they'll file a summary proceeding and also file a small claims matter. And so the court tracks the cases together so that we know what's going on one side and what's going on in the other, so that there's no confusion as to whether or not there's a judgment on the eviction matter, a money judgment on the eviction matter, and also a small claims judgment that's covering the same rental months, for instance, as the rental months that were covered under the summary proceeding. So we do see some of that, and the way that the court has been handling those matters are to make sure that they're tracked together. We can tell from the caption whether or not the cases are related, and then it just takes a cursory view of the months prayed for in the summary proceeding versus the months prayed for in the small claims matter to see whether or not they overlap at all. An interesting argument, and we've seen it on both sides, and I can't say that the court has actually had to rule on it yet because the parties have been able to reach a settlement negotiation, is whether or not the landlords have been rent in a non-payment proceeding, and they just want the tenant out.
I apologize, Judge Rice. Can I ask you to repeat that because you muted you said right when you started to say the landlord and it muted yourself. Would you mind repeating that? I apologize.
Okay, can you hear me now? I'm sorry.
We can hear you. Yes, I apologize.
Okay, good. So an argument that we've seen a number of say, I'm willing to forego this rent. I just want the tenant out. And we haven't actually had to rule on the matter because the parties are able to reach a resolution so far, but it will be interesting to see what we do in those cases where the landlord is refusing to participate in the ERAP program for whatever reason, and then go on to bring a holdover proceeding and say that they want the tenant out, and how that will play itself out in the courts. Sorry, I saw a question.
I did see that someone in the attendees has their hand raised, so I did reach out to them and just see if they had a question that they wanted to pose or if it was an accidental hand raise on their part.
Okay. I know that Bob had raised this earlier on in his presentation. We definitely have seen petitioners argue that the ERAP application does not stay a holdover proceeding. And again, we have not had to rule on these legal arguments because the parties have successfully been able to reach resolutions on their own. And it's just a matter of approval resolution for the court. And I really haven't seen a settlement agreement that I haven't approved of yet, where both sides are happy with the resolution and have been able to come to an agreement that doesn't fly in the face or shock the conscience of the court. All right, I see. Nope. All right, so now that I just wanted to make sure I open it up for any other questions, because I want to make sure that the view from the bench is sort of reflects.
Muted again.
And things that we've seen thus far.
Absolutely. If there are any questions that anyone has for Judge Rice, I encourage you to put them through. I know specifically from my perspective, when I started seeing some federal moratorium decisions being issued, I started wondering what effect that might have on if there were any creative arguments being made at the state level based on some of the federal decisions. Have you seen any of those? Is that something that's even an issue, or is that something that popped in my head for no reason and shouldn't have been worth concerning myself over?
So when there was a brief stint of time when the federal moratorium was still in play and the state moratorium had expired. And I want to say that was maybe for a week or two. And when that happened, we did get a good number of requests for immediate warrants. But the state law then kicked in and it was retroactive. So there was pretty much no issues in terms of how the federal and state law either coincided with each other or were contradictory to each other for that brief 1 to 2 week period.
I would also say that tenant safe harbor, right, was
Yeah.
not struck down and was always, active during those times where the eviction moratoriums were being challenged 6 ways from Sunday.
Yeah.
And that's what I kept going back to, but I just wondered if someone out there was trying to be creative with the argument, and it just always interested me. I always wanted to hear from the bench's side whether or not someone ever was creative enough to try and make that argument.
No, it was less creative and more just flat out, there's no moratorium, judge, I want my warrant. So, but again, we have been very fortunate where we have attorneys for the day come into the court, and even the court in our ability to help or assist both sides with being able to reach a resolution that both sides can live with. We've been able to essentially not have to go to trial, and we haven't seen many trials during the pandemic. Virtual court has been a challenge in its own respect in terms of gathering and exchanging evidence, and so that is, I think, a process that we're all learning how to manage and deal with. So in terms of virtual court, the court has been very lenient with both sides in terms of being able to exchange documents and exchange evidence, and really be able to use Microsoft Teams is what we're using now, the breakout rooms, in order for the parties to be able to discuss things both in front of the judge or, outside of the ears of the court, so that the parties are really able to reach a settlement. And the court is still proceeding virtually. We have in-person court and virtual court. So if the parties need to appear virtually, they just have to notify the court so that we can provide them with the link necessary in order to proceed virtually.
And so from the perspective of looking at the Attorney for the Day program specifically, you were talking about a lot with negotiations, settlement agreements, and just from a practical standpoint, how often do you see where negotiations aren't successful through the Attorney for the Day program? Kind of what we were talking about earlier when Vera was speaking, that is the goal, is that you reach some kind of settlement agreement day of. And I just kind of wanted to give everyone a perspective of how infrequent or frequent it might be that settlement negotiations are not fruitful, basically, from your perspective.
From my perspective, it seems as though the settlement negotiations are always fruitful, even if the final result is that you're going to set the matter down for hearing. Having the ability for the parties to be able to sort of hash out what their strengths and weaknesses are ahead of time is always helpful in terms of seeing, where the parties may stand and where the parties might want to go in terms of the direction that they want to see their case go in. I mean, Bob Romaker did speak about the Attorney for the Day knowing what the client wants at the end of the day, or what the client needs, what the client's looking for. Is a judgment going to hurt them? Do they need more time? And I think that that is one of the main responsibilities of the attorney for the day, is figuring out what the goal of the client is and seeing how they can help the client reach that goal. Because maybe if the goal is you need extra time, then maybe filing a hardship is a good idea. Maybe it's not a good idea if the goal is something else. So it's strategically speaking, definitely knowing the goal of the client at the outset is key. Also, for the attorney for the day, being frank with the court and the bench about what it is that the client is seeking is also may help in negotiations. If negotiations are breaking down, or you feel like you cannot get to that end result, letting the court know what the client is seeking, or where the parties seem to be reaching an impasse, is also helpful.
So just kind of going to elaborate a little bit off of what Vera discussed and kind of the practical way that the program runs, do you have any specific suggestions that you wanted to elaborate on, or from your perspective, you think may be helpful for a potential volunteer of the program to know, like going in? So a lot of people attending today, are wanting to participate in this program, probably have never done so before. So do you have any suggestions on, how to make this as best of an experience for both them and the client as possible, and the court, of course, as possible?
Well, I would definitely say that the attorney for the day program is the best way to get your feet wet in terms of taking on a case in an area that you maybe are not familiar with. I would say that Rylan and the individuals from Legal Aid that come to the court and administer the program are very helpful to the attorneys for the day. They definitely don't leave you in a sink or swim type situation, and can walk you through the court process fairly easily, in terms of just getting the ways of the court, first calls, second calls, when a case will be set down for the next appearance, sort of the script to give the client in terms of what they can anticipate for the next steps if they're unable to reach a settlement. I think that's also helpful in settlement negotiations. Definitely coming to CLEs like this, where you get the nuts and bolts of landlord-tenant law. So that way you're not going in completely blind. I think it's helpful for the clients and helpful to the court as well, and definitely helpful for settlement negotiations in terms of being able to have a fruitful discussion with the landlord about where you think as the attorney for the day, where you think the case might go if the parties are not able to receive to obtain a settlement. I think are really helpful. I know our court is very welcoming in terms of explaining the court procedure and process to all the practitioners that come in front of us. So it's okay to ask the court about what the process is going forward, or what is the next steps to anticipate, so that your client is well informed about what will happen next.
Awesome. Thank you so much, Judge Rice. I think we do have just a couple more. We have a couple, oh, it looks like Bob, you guys privately addressed some of the concerns, or the, not concerns, the questions that were asked. So I think that unless you wanted to, did you want to address the question live so that the other attendees might know, or do you just want to leave it where it is?
I can address any questions. That's fine.
It looks like Bob and Jasmine answered the question.
Oh, okay.
So I didn't know if they wanted to pose it to the group and their answer to the group as well, just in case anyone else might be like secretly holding in the same question.
I guess the question is, do the ERAP eviction protections apply to LRAP? And just for myself, I don't know much about LRAP except what's on the OTDA page that I linked in my answer. But I don't think that they do. I haven't seen anything that indicates that they do, especially because one of the eligibility requirements for LRAP is when you have a tenant that is not applying for ERAP. So I think that that's unlikely that those protections would apply in the LRAP scenario.
Yeah, I would agree with that as well. The protections are written very explicitly into statute, and there is no statutory provision besides appropriation language for the landlord assistance program.
And from the bench's perspective, we haven't really seen many issues raised regarding the LRAP program. I do ask the landlords questions such as, have you received any assistance, rental assistance? And that would cover either ERAP or LRAP for the months prayed for. But that's essentially the only question that the court sort of dives into in terms of that.
We do have another question. Will the court ask landlords if they have applied for LRAP to make sure they are not suing the tenant for money they have sought LRAP assistance for?
Yes, the court does ask, has there been a hardship declaration? Has there been an ERAP application? Has there been an LRAP application? And if so, what were the results?
Awesome. Thank you. All right, well, I think that we have exhausted all of the questions and we are just about at time. So I just wanted to thank you to all of our panelists today. I think you all did amazing. Thank you for everyone who is attending. Instructions for how to submit your evaluation form are at the bottom. All of that gets sent to one person at LASNNY. His name is Peter Rassett. So feel free to send all of that to him. If you have any questions, follow-up questions from the presentation, you have my email address. Feel free to contact me. And again, I would just encourage those of you who are interested in the Attorney for the Day program but are a little nervous to go in and observe. Also, we currently host it in Glens Falls, Troy, and Albany City Courts, but it is something that we are wanting to expand, absolutely. So if you are wanting to look into expanding the program into your prospective court, please do not hesitate to reach out and express that interest to me. So with that, I will let everyone go. It is 4:30. Thank you, everyone, and have a wonderful day.
Thank you.
Thank you.
Bye.
Thanks. Take care.